What still medical admission? Oh, all right.
Well, it's with your lordship's kind indulgence, my lord.
Ah,
Fixing an early date of hearing, my lord, for final hearing matter, my lord, where the issue
have you have you filed any application?
we have filed an application, my lord, IA 1 of 2023,
Oh,
my lord.
yes.
But
All right.
matter,
1910.
my lord,
1910 for early hearing. Yes. Huh? Hey, what do you want? The final hearing, Mr. Tell him if he wants final hearing, then he has to move an application for early hearing. Yes.
It's an early date of hearing.
Not that Millard. This matter was referred to your lordship's Millard.
So you don't want its listing, don't want its listing, right?
No, I want to say something Millard that is different. Here Millard, this matter was referred to your lordship's Millard. Instead of hearing by this that matter by the learned single judge, this matter was referred to honorable division bench. So far it is not listed Millard. Once it is referred,
That's what we are asking. You want its listing, right? For what purpose? Final hearing.
yes, Millard.
So then do like that. Every day we are required to tell that we don't grant final hearing by memos, right?
Right.
Lordship, this matter regarding the public interest litigation, Lordship.
What is the
44 of
urgency?
22, illegal.
Fresh filing.
No, Lordship, it is the 44 of 2022 matter.
What
So
is the
legal
urgency?
enforcement is going on, and the respondents also, official respondent filed the counters also, Lordship. It may be listed for the.
Final hearing. So
No,
move
Lordship.
an application for early hearing. Same thing.
No, Lordship, this one is not for, this one is for the listing only.
IA is pending, some IA is pending.
Yes, Lordship. Interim
Which
reliefs we are requesting, Lordship.
For consideration of that IA on 20, this thing, 19th.
Please, Lordship.
IA it will come up, Mr.
Please.
if it is pending. It's no,
Please.
finally it won't be heard. Yes.
No, please.
Yes.
Your permission, may I mention two petitions? One is for interim relief. There is an imminent threat of coercive action being taken by the GST department, requesting for listing GST department, Manats. Could it be tomorrow, Manats, subject to your lordship's convenience, Manats? Tomorrow, day after, Manats?
Day up,
Much of.
1910. Yes.
Manats, 7th, Manats, 18th, Manats?
1810.
18th.
Right.
Wait, much of it.
Yes.
Permit me to move a lunch motion in a medical admission matter.
Oh,
Yesterday, midnight counseling started. Today,
midnight.
midnight notification came, my lord. And like, lordship's kindly, my lord.
Yeah. What is, speak into the mic, madam. What is the urgency? Yes. But
It is not numbered.
why?
Some objections was kept by the
Tell. There was a direction to file. I mean, we had asked you to file some papers. You didn't
yes, Your I have filed it.
file.
Yes, ma'am.
When?
Filed more than
No, madam. If this statement is found to be incorrect,
yes.
we will proceed against you. Right? Because we are being told that you have not filed. That's why it is not listed. If you have filed, and if the statement is found to be incorrect, we will proceed.
I gave the letter.
Letter. You are an advocate, right?
Yes.
That you know what is the procedure of filing documents in the court.
The names of the
Huh? Huh? If you have complied with the directions, it will come up on this thing, Thursday, 1910. No, if you have complied, like writing letter, I mean, like letter means, no, you were asked to comply something else. If you have, Yes.
Subject to your lordship's kind, my lord, IA has been filed, my lord, in a fine hearing matter. My lord, your lordships, this is a challenge to the rules. Your lordships are pleased to direct, my lord, that any recruitment will be subject to outcome of writ petition. My lord, petitioners, my lord, are not able to make any applications. I filed only IA to receive their applications to be able to. Last date of applications is 21st of October.
19th.
I'm grateful.
Yes.
No.1.
The order is there, right?
Yes, my lord, these matters may be posted to tomorrow, my lord, because.
No, not tomorrow. There is an order.
Yes, my lord. My lord, I would like to.
Why to keep it pending? We can't take a different view tomorrow. Please understand. You have appeared. Yes. Same order, Mr. Third, this thing. Item number
1326. 1326.
1326. All.
A lot of senior counsel is appearing online.
Wait, please, my lord, I am appearing for the writ appellate.
Similar order. This is order. List for analogous hearing along with WA number 920. No, this thing, oh, there is an application for condonation of delay.
Delay.
Don't write that order.
Yes, ma'am, 12 days.
Ah,
12 days delay.
this thing IA 2 of 23.
Early date because they are insisting for a
Yes,
implementation of the order.
Mr. Whenever you get them served, please move. We will immediately list that order has to be granted. Like we were granting, but then we realized that there is an application condonation of delay.
Oblate, oblate.
Yes. Who appears? Third, learned counsel for the petitioner submits that a perimeteria pro. Don't give date then. Notice.
May I please the lordship? My lordship, this writ is filed for not considering an application for organizational election held within the party, my lordship.
What happened to your head? There's something.
I met with an accident, road accident, my lordship.
Yes.
Election was held on 29/2022, my lordship. Page number 12, my lordship.
Under which provision, Mr.?
Under
Which provision? Is Mr. C This is
Under
very,
section 28
Mr.
of RP Act, my lordship.
This is unfortunate, Mr. I don't know it's intentional or unintentional. We can't decide, but see what is it. I mean, this representation which you have given is incomplete, right? 29/9/2022
My lordship.
is incomplete. Copy prayer is not there. Then you have been informed by the Election Commission on 5th of October 2023 about the outcome of your representation.
My lordship. They have
And you are saying you are again seeking a direction to decide this thing, the representation. What is
also it's a letter.
under which have you examined it? Under which statutory provision?
Under section 29A of RP Act, my lord.
How? What does it? Have you read it? Section 29. Is it a representation in the manner indicated under 29? When the law provides a mode of doing a particular thing, it has to be done. Have this with the liberty to approach under 29A. That is understandable. Don't invite an order. We are not inclined to entertain. We are giving you an option. If you want an order to be passed, we'll pass an order.
Because elections are approaching, my lordship. We are calling since last 1 year before the Election Commission of India.
This is misleading and misconceived, this thing, petition, Mr. This thing you have been, in response to your representation, you have been informed by the Election Commission of India.
My lordship.
And you are still seeking a direction in this petition
No,
that they should be directed to decide your representation.
in the letter, they have
And this-
clearly mentioned to
Had
update.
you, Mr. Right of registration of a political party is governed by statute. Have you read it? Have you read section 29A? You have not been elected.
I'm not.
You are not. Then
The new committee, my lordship. For the new committee, I'm asking.
So, all right, fine. That's it. Anything else?
Just
Anything else?
small summation, my lordship.
One
For the new committee.
suggestion to you is you have the liberty to withdraw this petition with the liberty to approach Election Commission under 29A. Or the other thing is we pass an order. You can argue whatever you want to.
Liberty,
We
may
will.
Liberty, may
This log, what is this? Your incomplete copy of representation you are annexing. What is this?
What we have
Not
submitted,
fair.
I have submitted before this honorable court.
Where is the prayer in the this
Page number-
misleading, Mr. After arguing the matter to some extent, learned counsel for the petitioner seeks leave of this court. So, deliberate and the other contestants need not position of yes. Oh, yes.
Kind permission, my lord.
Huh?
The lordship's kind permission, my lord. In fact, being one of the partner advocates, our name has been reflected as one of the counsel for respondents one and
Which is?
that nine, item 9.
9. 9 he is appearing.
But
Yes.
the
I
branch,
was already, Mr.
inspector has that.
Nothing, no branch. It's his petition and we are hearing him on admission. Don't listen. We want to put an end to this practice of seeking adjournment on behalf of petitioner. Why? It's his case. You will be heard when you have not filed any caveat. Then
I just wanted.
don't appear.
Place it before.
Office is directed to delete the name of whatever.
Lord, I have instructions to appear on behalf
Or law associate. Delete. Yes. Yes.
Lords, this writ petition, my lord, challenging my lord, classification of the loan account as a fraud.
So you can, measure has been taken against you under section 13. You have approached DRT that appeal, that is pending.
Yes.
And you will file another writ petition, right? You raised that issue of the classification of this thing, your account in the proceeding before DRT.
Covered by the Supreme Court judgment in the case of Rajesh Agarwal, my lord. And my lord, the-
Covered.
The judgment of Honorable Supreme Court, my lord.
So what covered? What is that?
The Supreme
You
Court
can
has-
be allowed to file a writ petition and prosecute your remedy
No, no,
before DRT simultaneously, two remedies.
DRT, this matter is not the subject matter in the DRT.
Also, that's what we are saying, that you challenge this order also before DRT. You have already, there is something called
Lord, sir, I have raised.
doctrine of election of remedy. You have elected your remedy
Yes, but I
under
have-
section 70.
But DRT
And Mr. The law does not prohibit you from raising this ground under section 17. Which
My
law
lord-
prohibits?
My lords, my observe says, because my lord, DRT says, my lord, it is outside the purview of adjudication under section 7. My lords, my observe and dispose of, my lord, I raise this-
No, but you have taken,
Yes,
where DRT has said it is outside the purview.
My lord, in a interim order passed in the stay application, my lord, that order copy is not enforced. The DRT has stated that we will not go into the aspect of classification
Why?
of fraud.
Which law prohibits?
My lord, I'll place that order copy, my lord.
Learned counsel for the petitioner, praise fund is granted. Have you filed the KVA?
No, I have instructions to appear on behalf of.
You supply,
I can print other like this, it was school.
say, admit notice.
This, my lord, in this also, my lord, IA2 is filed, my lord, to receive applications. They are not receiving the applications of the petitioners.
As an interim measure and as same order which shall be permitted to submit application for the post of
School assistants, my lord.
school assistant. Result shall not be declared without leave of the court. Participation shall be provisional in nature and shall not create any equity in favor of the petition. But what happens? You did not argue for 3 hours. Huh?
That I have, I'm sorry, my lord.
You are not arguing for 3 hours.
I'm grateful.
Yes.
I think that,
With these mailers, I may permitted to
Huh?
video conferencing mailers.
Yes.
Last occasion mailers or lawsuits are directed me to verify with the mailers Savitri's case. I verified mailers, myself mailers,
No, what verified?
not.
No, see, Mr.
Proceeding.
You have
I
impeached.
made a mailers, 10th respondent mailers, court has made a party
Huh?
respondent. Therefore, mailers, I may be permitted to not press on the same mailers. I may be permitted to mailers submitted one aspect mailers.
No.
Mailers, I made a mailers, 10th respondent as a party mailers, 4th as a party.
No, Mr. You remember the order which was passed on the last occasion? You are Mr. Ram Murthy, right?
Yes, mailers, I am.
So then an order was passed last occasion in your presence. Do you know?
I'm not aware, mailers, that order mailers.
No.
I may be permitted to mailers not.
Mr. Last date also you saw that you are not aware. Then why are you this thing?
I am mailers, peruse the
Not aware means
mailers.
last date also you said that I am not aware of decision of Supreme Court. Today also you are saying the same
Now
thing.
I am aware,
We-
mailers. I am now aware, mailers.
Huh?
Now I am aware with the mailers, judgment of mailers Savitri Devi.
No. So he should delete then, no? Ask him whether he wants to delete.
Sir, as per your submissions, you are not pressing on respond number 10.
Yes, mailers, yes, your lordships.
So then you delete.
I may be mailers, other alternative mailers steps may be taken, well permitted.
Learned counsel for the petitioner seeks legal.
Oblige.
I can even view of the picture.
May it please your lordships, my lord.
Yes.
Petitioner was my lord. The court manager, my lord. having
But what this is again 2 and 3 in personal capacity.
yes, my lord, with regard to that 2 and 3, my lord, and I permitted to my lord, bring to your lordship's notice. As to the grounds, my lord, raised, my lord, at page number 10, my lord.
No, no. So you must first be at the outset clear. Is it malice in fact or malice in law? What are the averments? Let's see.
With regard to that impediment only, my lord, I am pleading, my lord, in the one of the grounds, my lord, in the grounds. Which, my lord, your lordship.
No, Mr. You are well aware with regard to legal position. If you are pleading malice in fact, then only you are required to implead a person in a personal capacity. Right?
Yes.
If it is a case of malice in law, then there is no such requirement. So you are this thing alleging because they have instituted departmental inquiry against you.
So therefore, there is no such, my lord, modified in my allegations, my lord.
Then why have you
Findings are, my lord, against the charges, my lord. For the time
we will have to then direct deletion. Are you ready on this aspect that what is the office objection?
I am permitted to withdraw, my lord, these two petitioner respondents, my lord.
No, you delete this thing, their names. Let them be there by designation. That is all right.
Yes.
The objection is by name you are impleading because they have instituted, you have committed alleged misconduct.
I oblige, my lord. I very much oblige to cite those names, my lord.
Learn it count in view of office objection.
May we please?
Yes.
My lord, I am appearing as party in person, my lord. I filed a public interest litigation against land largesses given by state to an international arbitration center.
Similar petition you had earlier filed. Right? In any case, it will go before another bench.
My lord, I have withdrawn with the liberty to seek.
No, but I will not hear this. Let this petition be listed before a bench. No, he has already challenged it and then. In which manner? No. Yes. Yes, madam.
The present contempt appeal is filed.
14. Yes.
Present contempt appeal is filed challenging the order dated 13/3.
So we had issued notice on condonation delay. What happened? Served? Served?
Yes.
None for respondents. Yes.
May I say one thing, my lord? Stay petition is also pending, my lord. But kindly grant a stay.
We will hear on admission first, madam. When will you argue on admission? We have condoned the delay today. We take it up when day after tomorrow.
Right.
Let the appeal be listed for.
Right, please. Respondent.
That's
I will counter also.
What condonation?
Condonation of delay. And then
in both the
What
petitions.
representation has been given? What happened? This order was passed on 10/6/2022.
10/6/2022 is the order against which appeal is filed. Police protection is ordered. Police
We
protection,
know, but what, you must have read the order of.
police protection was given to the writ petitioners therein, on the basis of which we are sought to be dispossessed of property.
Read para 6. Police protection, there is no order giving police protection.
No,
This
it
order
says
was
there
passed
is
on
no
10/6/2022.
Yes.
Have you submitted a representation?
Yes, yes, they submitted,
You
they
have got the
submitted,
representation. You have got the police protection.
yes.
Yes.
All.
Yes, that is why the appeals. We came to know about this order only when the police acted on his alleged on the said
What is it? It's
representation.
still being provided. Protection.
No,
What-
there's an interim order in our favor in the writ appeals
Ah,
directing that we shall status quo be maintained.
no, so status quo and police protection, nothing. What?
What had happened was, my lords, may I just tell you a couple of facts. The writ petition was filed complaining of lack of police protection based on an injunction order in a civil suit. On the learned single judge disposed of the writ petition saying make a representation and the police shall grant them police protection. Agreed by which persons in possession of the property who are not parties to the writ petition and against whom an implication of police protection was read into filed these two writ appeals. There was an order of status quo, leave was granted. However, in the last two times, my lords, the applications for condoned delay was coming up. At one stage, your lordships voiced an opinion that condoned delay may be
Yes, we will allow condonation delay and hear it after vacation.
Only 2 points for Lordship kind consideration. No? There are 2 appeals. As far as writ appeal 332 is concerned,
Ah.
my lord, as well as both appeals are filed by third parties to the writ petition as well as third parties to the civil suit. My lord, my clients obtained an injunction before the civil court when there was, my lord, interference, the kind of, my lord, a kind of a law and order situation made, representation was made to police saying that we are protective injunction, so give us protection. That representation was not being acted upon, therefore it was filed. The order was passed. Then, my lord, these people who are third parties, who claim property differently, set up by the defendants therein who suffered the order, my lord, filed a writ petition alleging that they are being disposed in the guise of the orders and injunction. So they are third parties. They filed a writ petition separately, and that writ petition was dismissed. Appeal was dismissed.
So writ petition for what?
My lord, saying that they are illegally being dispossessed in the guise of the police protection. That was considered by learned single judge a detailed order. That order was challenged by them in the writ appeal. Writ appeal was dismissed. Matter was confirmed in the Supreme Court. You know, those facts were suppressed fully by these people.
We will hear after this thing. We'll write today. We
But
condone.
status quo order is my lord, obtained by third parties against the proceedings they got with other people. Is
status
really
quo is-
militating against us. Not police are, my lord, saying that there is an order against us.
But it's 16/3, 16th March it is operating
That's
against.
well, I filed a counter.
We'll hear you after this thing.
Some date lost.
30th October.
May I request 7th November, my lords? That whole week I am out of the first week. I have matters in other high courts. So first Monday after that.
7th, I may have personal inconvenience, my lord. 8th, lord.
8th.
Subject to your lordship's calendar. 8th.
Heard on ISO and so results assigned duly support. Yes, madam.
This matter lordship may take up next week. My senior has a throat infection. She is not.
Learned counsel for the petitioner, appellant, praise for accommodation on the.
Wait, please. Apologize for my absence and last second.
And I'm seeking new application, my lord, for, I was not a party to the writ proceedings, my lord. And also, my lord, delay continuation petition is also filed, my lord.
You can be heard, right? What is the direction by the learned single judge?
The learned single judge has passed an order directing the respondents to consider the application filed by the respondent.
You have some claim in the property, right?
Yes, my lord.
You are the owner.
I'm the owner. I'm seeking a
Fine.
right on the
So
property.
what you can also be whether this order has been given effect to? Direction passed by learned single judge has been given effect to? No, not yet
aware of it,
implemented. So what we can do is we can modify this order and you can also be heard by respondent number 2, like district collector, right? Yes, who appears, madam? Yes, so let him be heard. This intra-court appeal.
This will have the last call for a recall from the council.
Record?
If the existence of a federal certificate is in dispute.
Yes. That's what they are telling. Yes. So what have you done?
Bereavement in the family, he could not appear before this court. That's my custody.
Which date?
Friday.
I'm
Yes,
also for the appellants.
So yes.
Yes. Will also please to pass interim orders in all the 3 matters. And directed the learner government feeder to produce a record.
Right. So when do you like? How much time do you want?
Friday.
On reopening.
No, not Friday. Either before that or after that. You will have it on Thursday or after.
Yes. Thursday.
Thursday, right? No, if there is a possibility of production of record, then only. Otherwise, don't time and speak on that day.
After the reopening day, after reopening.
All right. So Monday.
Yes.
13:10. Learned. So and so, whatever government pleader.
I plead your lordship. I am representing Mohammed Nasiruddin, my lord.
Yes.
This is the matter, my lord. The first respondent filed a writ petition. And this honorable court, the learned single judge is passed the orders, my lord.
Yes.
Your lordship kindly see the last para.
So that appeal has come up, filed by the work board.
Not yet, my lord. Not yet they filed it.
You have not filed? Who appears for
Your
work
Lordship, we
board?
have filed it online, but it is written, we are filing it, is again, Your Lordship, but it can be taken up. We got only last para of the order objection. First para is okay.
Day after, we shall we take up along with the appeal of work board? Day after.
As may be pleased by you.
Day after, let them, you file it, Mr. Today. You will take it up along with your appeal.
Yes.
And for respondent
Day after
1.
tomorrow or any Friday, Your Lordship, any day.
No, not Friday, either Thursday or day after, whatever.
Thursday, Your Lordship.
Thursday. All right, 19th. Yes. Learned senior counsel for the app.
Much obliged.
Mr. Rao.
General Rao took time for filing immediate application.
Mr. Rao, have you filed?
23, yes. I 2, my lord.
So you have got the copy?
No, I don't. I did not get.
Did not get. Sir,
IA 2, my lord.
which is the IA 2, madam? IA 2.
Copy.
Respondent 6 to, proposed respondent 6 to 21, my lord. There's 16 candidates, my lord.
All right, we'll include them.
Notice has to go to them.
Yes.
Notice has to go.
All right, yes.
But may I request one small? I'll take out urgent notice, my lord, if you lord.
Yes.
On Thursday, my lord. I'll try to serve and come back, my lord.
All right. Learned counsel for the
Obliged.
Human Rights Commission.
Yes.
Human Rights Commission to
What?
December 20.
December?
20.
See, you have been telling us that we will do it.
Yes.
Progress with regard to appointment.
I have filed the additional counter also. So progress was made, but now
What progress was made?
the notification was issued. Notification was issued on.
That we all have, I think we have recorded all those facts.
Yes.
Then
14th of August.
you told us 6 and 64 application and all that.
Yes,
Then what happened?
1 minute there is.
Code of conduct. What to will list it in second week of December?
I leave it to you. I leave it to your lordship.
What do you?
The only thing is during election times itself, the human right violations are at the maximum. That's the reason I had insisted on the last occasion and made a request to the.
What to do? They have brought about this situation, right? We can't ask them. It's a code of conduct. No appointments can be made. You know that. Learned special government pleader. Further.
I'm appearing for respondent GHMC, my lord. We seek 2 weeks time for filing additional counter affidavit. Recently, the ward committees have been established regarding the establishment of the ward committees.
You appear for municipal administration.
The Greater Hyderabad Municipal Corporation, GHMC.
GHMC, Learned Council for GHMC.
So GHMC, my lord, this matter pertains to the fatal incident where a girl and boy were swept out in a inundation, my lord. In this matter, compensation is already paid, my lord. I'll file our counter affidavit along with Lordship may grant 2 weeks time for filing counter. Compensation is paid to the family and the
3
steps
weeks
taken.
time to enable him to file counter.
My lordship, I have compulsory retired from government service by way of major penalty by forging the docket orders of this honorable court, my lord.
All right. So what is this IA you have filed complete petitions? 3 complete petitions. Whom do you want to implead? See, madam, complete
Let me
petition.
complete, my lordship, 1 minute. I will
No, no,
complete
no.
the case.
Complete means this is listed for orders on IA, mister. This, see, you have the cause list.
No, no, I am having my, the case first
So-
time, it is a first hearing, my lord. That's why I am.
No, no, there are several IAs, 4, 5, 6.
Based on the case, it automatically it will be ordered, my lord. That's why 2 minutes. I have been
So
compensated.
with that by way of penalty on the basis of a non-existent order of this court.
by an incompetent authority, not the competent authority. Number second, my lordship, is forging the order of this honorable court. Forgery. That forgery order has renamed as order vacating the interim orders. There was no vacation of interim orders. They have renamed that forged document to order vacating the interim orders. Accordingly, they have imposed the penalty. Based on this, my lord, another point is that my OA was admitted.
What is IA?
My lordship, my OA was admitted.
What has happened in this complete and the order sheet? He says it is coming up for the first time. Notice has not been issued on your this petition.
Things have, they have also filed the replies.
That you are saying it is coming up first time?
No, no, sir. It was already served and they have also given replies. I have also filed the reply statements also. Everything completed long back, my lordship. In July 2022, it was completed. All pleadings were completed, my lordship.
So why it has come to this bench? This is a service, service matter, right? Compulsory return. It is not a judicial officer. Why it has come?
They have served, they have also given replies, my lordship.
What recall? What recall? We doesn't know anything. What is the IA 4 of 20? Who is appearing for respondents? None.
Mr. Balakrishna is appearing on behalf of 10 respondents, 1 to 10.
Where is he?
Apologies, my lord. Apologies, my lord. I am not aware of the matter. I'll inform my colleague.
So there are several 4 applications for impleement seeking personal capacity.
A respondent is also a party in person.
Huh?
Respondent is a party in person.
Who?
In Balakrishna is party in person.
There is a mistake, my lordship, in the record.
No, Mr. C. We have to deal with your case, right? You are not assisting. You are not expected to assist us because you don't know law.
No,
so therefore we are trying to find out. There is a procedure of deciding a case. Interlocutory applications have to be dealt with first. You are not telling why you have filed 4 IAs and why do you want to include those person. We are trying to find out from your IA. So, Mr. Then these 4 IAs are pending. Have you filed objections to this?
So I'll verify, my lord. I should kindly pass it over.
Pass over, Mr. Wait.
Yes, my
You see these IAs. What
yes.
He wants to include and what is it? See, pass over. Give it to him, but give the record to him. It will immediately be called. Password. Let him see. What IA?
The IA is not fixed every day.
Early date. Yes.
May I permit to make a mention? Millard, in this matter, Millard, we also filed an application for vacate of the stay order, Millard. On the last occasion, as on 5th October, the matter is listed. Your Lordship directed to implead petitions are ordered. And implead petitions are there. 2 implead petitions, 5.
We'll consider at the time of hearing.
Your Lordship's ordered them.
Ordered the implead petitions. So he said he has no objection.
Yes.
All right.
And
So, Mr. Let us finish first 2005 and 5 matters. Little of few of them are left. So, we will consider your application in first week of December, right?
First week of November.
December. We know.
Whether at the 10 points given to
All right.
is it valid?
Yes, that is the only point.
First week of November.
Your Lordship's
Last week of November. Last week of November. Yes.
Middle week of November.
All right. Yes. Or let mark the presence. Let IA be listed for.
But it's not listed, Millard, that's what.
Last week of November.
Again, Millard, our MPs will not come because the matter is listed for final hearing. So, Millard, my
Not listed, madam. It has come up for his orders on fixing a date for hearing. We have said that we'll consider it in last week of November. Hopefully, by that time, we'll be able to finish old matters, old rate appeals of 97, 98 and 2004. So we can fix some time. You prepare a synopsis. Yes. Please. We will see that on that date. We don't know.
Otherwise, the entire thing becomes expected.
Nothing. Don't worry. We will.
Transfer.
Yes.
Cannot.
We will see. I mean, last week. No. Not that means allowing the petition, not like this. Yes. Yes.
At least one date, maybe.
Date last week only 5 days. Whatever date you want. Last week 28/11.
Yes.
IA will be considered for early hearing. Madam, it is not listed your IA. We didn't know.
But your Lordship may see 5th October order. Josh,
All
direct
right.
talks.
Let so and so be listed. Mr. Rao.
Where the petitioner was declared a non-local, he has studied qualifying examination in Karnataka.
Oh.
Just pass the synopsis.
That is relying upon judgment of the Honorable Court, Miller, that undergraduate. 2 years more out the state. But considering that the Lordship was pleased to hold
No, but this benefit of reading down, we have denied. No, you know that we are bound by our views.
I do agree, but the petitioner is.
Delay and latches. What were you doing?
The petitioner is.
No, when did you file this petition, Mr.?
August 16th.
16th August.
Yes, my lordship.
So, but see, under the this thing definition of local candidate, you don't fulfill this thing, no?
So, though he has studied a 4.5 years degree from neighboring state Karnataka, he has completed 10+2 from Telangana and Hyderabad.
Yeah, but what is the requirement under the rules?
My lordship, I just want to draw the attention of this honorable court. Go to the prospectus which was being issued by the respond number 2 and 3. I just want a 2 minutes time.
No, 2 minutes, you take 20 minutes, there is no problem, but we are just trying to interact with you because why we are posing question, because we have already dealt with this issue, right?
Yes, right.
We have written judgment, so we know that under the rules, are you entitled as they stand? Obviously not. You are not a local candidate. That's why now what is the prayer?
My prayer is, the honorable court may be pleased to direct respond number 2 and 3 to consider the petitioner for the admission into the postgraduate medical course under NEET PG 2023 in Telangana under local category to suspend the clause 4 of GPO number 646 dated 10/7/1979. My lordship. Now they are in the prospectus. They have clearly stated.
No. So tell us which is this thing rule which defines local candidate.
Local candidates. 646, page 15. He wants to seek suspension of your GOMS number 6, GOP 646, dated 10/7/1979.
Which? No, where is the rule, Mr. Rao? Rule.
Lordship, may kindly see it.
Which rule you are striking?
I'm seeking in the clause 4, my lordship. Page number.
Which page?
111. Yes, my lordship.
Yes.
May be permitted to read out.
Yes.
The clause A states that if he has studied in an educational institution or educational institutions in such local area for a period of not less than 4 consecutive academic years, ending with the academic year in which.
Clause 3 you are reading.
Yes.
Clause 3.
Clause A. Below the para 3. Clause A.
What is this? This is rule.
No, it's a.
What is it?
It's a geo.
Geo? No, but the admission is governed by rules, no?
Yes, sir.
Which rule?
Right, not.
Admission to PG course is governed by a rule, right?
Yes, my lordship.
So is it this comprehensive instruction? Mr. First, you must tell us under which provision, like the admission would be made. That tell us. Where is the rule?
They are relying upon the GOP 646. So I am challenging the clause 4 where it is mentioned in the GOP number 646.
Relying this, Mr. Rao, there are rules.
And GOP number 155, that is also filed. My file was kept here, somebody has taken away.
Oh.
GOP number 155, rules, for admission into postgraduate. My friend has filed it.
Which page? Chacha, you don't know. All right, his file has been taken out. So which page, Mr.
GOP 147, 146.
140.
5 and 146.
140. This is yes. Admission to MBBS BDS rules 2017.
Admission into postgraduate course.
Postgraduate. So this is
This regards to the post graduation course, my lordship.
post graduation.
Yes.
147.
This Geo 150. Yes, sir.
Yes, 147 are the routes. Where is this? Local and non-local. So this is Andhra Pradesh Educational Institution Regulation of Admission Order 1974, Mr. Rao. Where is that? See page 151. Reservation 85% seat shall be reserved. Mr. What is this? You file a petition, you don't know anything. Huh? Just seems you are not ready, right? You don't know. See, you have not in your petition prayed for relief of reading down of the rules. Relief of reading down of rules was given in case of admission to MBBS and BDS courses, right? And the relief was confined to petitioners therein. This is a PG course. This is not your relief. So what? Clause 4, Mr. First of all, under which rule the process of admission takes place? That you should know. Which rule? There has to be some rule which defines local candidate. What is this? Is this the way of assisting the court? You ask yourself. Huh? No, Mr. You. Mr. Rao, what to do? See, this thing file petition, the burden is of the court to find out the point and decide everything. What, like he doesn't know his case and not prepared to even prepare the case also. Filled up. Now what can? No, but you can't be treated, Mister. This unreserved seats are there, therefore you can't be treated as local candidate. You can't. You have to show your entitlement. Page Ah. Ah. What is it?
Eligibility criteria, Lords, may kindly see B, my lord.
Page
70 to bottom, my lord. A candidate should be citizen of India. Candidate who satisfies local or non-local status as per GOP number 646, my lord. Education Department dated 10/7/1979 are only eligible to apply for PG admissions.
Now, where is
My lord, next C, Lord. The candidates who have studied MBBS in the state of Telangana and Andhra Pradesh obtained degree are eligible. Only two. The persons who are passed in their MBBS in Telangana and Andhra Pradesh alone are eligible to the claim seats. Please. Other states, the other state candidates are not eligible unless they satisfy the local, non-local status as mentioned prospectus and the GOP number 646. Last two lines. Therefore, my submission lordship says, my lord, he studied in the state of Karnataka. The qualifying examination is a criteria for determination whether he is a local or non-local. Whether he is a non-local candidate.
And this requirement is not under challenge before us. How can it?
Yes. For local residents, it is injustice, my lordship. Why? Because whoever coming from other states and pursuing their 4.5 degrees, they are seeking the admission under the local category.
It's not that the whole thing is it, Mr. Rao? Whole thing is not reserved in favor of local candidates. There is some.
85% seats are reserved.
That
the non-local, unreserved seats are meant for take at regions of the state, my lord.
Just merely seeking a direction without challenging the provisions, what can be done? You should thank yourself for drafting such a petition.
There is an ambiguity of law.
No ambiguity. This is very clear. You have read it. You read it, page 72. Where is the ambiguity?
Page 72.
Page 72. Please read.
My lordship.
Page 70.
The P para, the candidate should be a citizen of India. Candidates who satisfy the local or non-local status as per GOP 646 Education Department dated 10/7/1979 Presidential Order only are eligible to apply for PG medical admissions. Again, the next para, the candidates who have studied MBBS in state of Telangana, Andhra Pradesh and obtained degree are eligible. Now, other state candidates are not eligible unless they satisfy non-local status as mentioned in the prospectus as per GOP 646 Education Department dated 10/7/1979. There is other para, my lordship, in the space 73. Candidates who are domicile of Telangana and Andhra Pradesh and studied MBBS equivalent course and obtained degree from other states in India, other country are eligible. Now, the petitioner falls
eligible means, I mean, it's not that they will be treated as local candidates. They are eligible to participate against 15% seats.
For other state who is pursuing here, they are falling under the local category. Now, who is the resident of Telangana is falling under the non-local category. It is injustice and it is.
Yeah, this is injustice according to you. According to you. What you have not challenged these requirements, right? Anywhere. You're saying injustice. We will write that according to you, according to Learned Council, it is injustice. Therefore, it cannot be struck down.
Petitioner is false and suffering a lot because he's not been considered as local.
Suffering means he should prepare better for next year.
See, already he has.
There's no argument, Mr. Everybody, you are also suffering, right? Not suffering.
So, yes, sir. Everyone is suffering, my lordship. Even I have a burden on me. So I have taken up the case. I have to answer my.
You have to argue properly. This saying that I am suffering, my client is suffering is no this thing. This no way of discharging the burden like this. That I am suffering, my client is suffering. Therefore, petition should be allowed. We wish that we could write an order like this. So easy, right? That petitioner is suffering, his counsel is suffering. Therefore, petition is allowed. So easy. What is this? You don't even draft the petition. You can't comprehend the controversy. What will happen? The petitioner should have engaged a better advocate. Then you would not have suffered. This is not this thing.
I'll file an amendment petition, my lordship. What permits me.
Do what permits means it is Your petition, do whatever. You know time is running against you. All admissions have been made, whatever is left out, your choice. This is not the way to file a petition and contest and argue that I am suffering, my client is suffering, therefore petition should be allowed. This is injustice. What, mister? We have written judgment on this, right?
Yes.
Have you seen
Yes, I have seen Lordship.
this? We have written a judgment on this postgraduate admission. Have you gone through it?
Lordship.
That what like arguing injustice and I am suffering, he is suffering. What can be done? We can't do anything. We are not doctors. You should go and get yourself treatment if you are suffering from anything. This is not the way to argue. This is nothing, mister. Tell us, you want us to pass an order, we will.
Any appropriate orders may be passed me on.
Huh?
What can I seek from this honorable court?
What, mister?
Time for filing an amendment.
I'll file the amendment petition. Court permits.
What? You are not making a prayer.
I'll file the amendment petition. Posted after 1 week, my lordship.
Learned counsel for the petitioner, after arguing the matter to some extent, seeks leave of this court to make amendment in the prayer clause of the. Password. Yes, we don't take at 2:30, madam. It's not immediately. Mr. Prasad, what happened? You appeared, no? Password.
Verified in the online, FPS is 511.
This call 28, madam. He is sitting there. He doesn't know it. Case has been. Yes, Mr. So what, you have filed 4 applications for impleadment. Whom do you want to implead and why? All? Notice has. When a person is impleaded by name in a petition, any idea?
Because of the.
No, any idea because of what is the legal position?
By interpretation is that they are.
No, your interpretation doesn't matter, Mr. Supreme Court, what Supreme Court says binds this court under Article 141. You may think anything, that doesn't fit. So why do you want to implead first IA, let us deal 4 of 21?
My lordship, when a major penalty was imposed by forging the order of this honorable court, forgery of a honorable court order, based on that imposing a penalty is a serious offence. The personally liable, my lordship, is a serious offence.
Service matters, the roster is not before other bench.
Other bench?
Cat. I know the cat.
Which bench?
Third bench. And the other in respect of the respond number 11.
No, Mr. This thing.
Respond number, how can you restrict?
No. So that's why this 4 of 21, 5 of 21, 6 and what do you say about this? Implead petition.
Implead can be not.
By name he is impleading controller and auditor general. We don't know. He is incapable of comprehension. We will have to, if this court wants to hear, we can't be dependent on him. We will have to engage a counsel for our assistance so that we can write judgment. This cannot go on that it is forged and forged and forged. This is, matters have to be systematically proceeded with. First of all, we will have to deal with implead applications.
I'll get seconds because my name is not entered because I could not know.
All right. So which date, Mr. Next date you tell? After vacation.
No, my lordship, kindly go to the docket orders.
Docket order he has to respond to those implead petitions. His name has not been mentioned. So we are asking you the next date.
My lordship, already they have
After we-
responded, they have given a
Only
reply
one,
also, my lord.
one objection, Lordship.
His name has not been mentioned. He doesn't have the file. Do you understand,
Yes.
Mister? He doesn't have your file also. He's praying for time. So we are giving it time.
Apart from that, my lord,
So it will come up on this thing.
My lord,
30th.
what is
October.
his name? What is his name? Respond number 11 or what?
I am representing to.
You come here. You, that person. You will land somewhere, Mister. Don't behave yourself, right? This is not the way.
No, no, my lord.
Behave yourself. He will take you somewhere else.
No.
No, this is what is being
I
issued here.
regret, my lordship. I regret. I regret, but
I mean, nobody is supposed to ask questions to us.
my lordship,
You don't have that stature. Otherwise, if you don't behave yourself, he will take you away. Our under, you will.
I regret, my lord. I apologize. My point is.
Yes, Mr. Praveen Kumar.
That the chairman.
Seek instructions, and we will post it on 30th October. Mr. Office is directed to take, Mr.
Apart from that, the chairman of the CAT has been, by name is.
No, it has been deleted. We will take it. You seek instructions on incomplete petitions. Learn it.
My lordship. 1 minute, my lordship.
30th October it will come.
My lordship, one submission, my lordship. Kindly see the docket orders 11th July 2022, my lordship. 11th July 22.
What is the order? You are here to assist us, right? Not tell us what to do. What is the order?
The order is, I have been directed to furnish the list, chronological list of events. I have already filed my list. I have already filed my lordship, those are not available.
All right.
So my lordship may be
We will
granted.
see on the next date.
My lordship.
We will see on the next date.
My lordship granted permission to file the list of the chronological events, my lordship. I
will
didn't repeat it because they have already filed. Served to other
He
side
doesn't
also.
have this thing. We have granted time to him to argue your IAs. 30th October. Yes.
Obliged, my lord.
Malas, kindly pass over these two matters, Malas. Additional request to pass over matters.
Why? Where is it? Pass over means what?
230 minutes.
Well, it's same case, Millet, mutation not carried out. Last
He
occasion.
has argued, right? He has argued. He has also.
Continue, then you'll have to continue.
He has to finish what is it. You make notes of what is arguing. Mutation does not confer any right on anybody, Mister. They will have to, they are respective this thing, since they are senior counsel, they are arguing. Our job is to hear this all in any, they also understand. But since the value of the property matters, so all these people have been engaged, they are arguing.
Yes, I'm aware.
So mutation doesn't confer, even if it is recorded in your name, you will not become owner. His name, he will not become owner. His name, he will not become owner. This question, if disputed question of title is pending between parties, it has to be eventually adjudicated by civil court. His grievance for the moment is he has not been heard. We have to hear him.
230 minutes.
Yeah?
230 pass over.
No, but he has already argued, right?
Yes, ma'am.
All right. No, but we don't see, we wanted to finish this in 10 minutes. That day it was not possible because the court had to assemble in single bench also for 11-6 matters. That's why we have list. This is not otherwise.
Yes.
Huh? Mr. Additional Advocate General has argued the matter.
Note down the points, ma'am.
If he has to say anything, we will hear him. If they will conclude, we will time bound matter.
Yes, ma'am.
15 since he was arguing and he was about to finish, that's why and he has to argue. That's why we are giving time of 15 minutes. You call him. Nothing, Mr.
Yes.
We are not deciding any title here. So, yes.
My lord, your lordship, list of dates, my lord. I was point about memo, my lord.
So you have told us he is guilty of suppression of facts. And
In that, my lord, the lordship had put me a question saying that whether you did you make an application for mutation. That's what your lordship had posed me a question, my lord.
Yes.
That was what I was answering. My lord. Your lordship may come to serial number 9, my lord, of the list of dates.
Yes.
My lord, already had made a request and a memo was passed by the government, my lord, at page number 37 my lord, of CA, the writable 579, my lord. In fact, that's where we stop now. Your lordship was seeing the memo at that stage we stop now. It's on 5th November 2004. Writ appeal number 579.
What is your title? Sale deed.
Registered sale of 81.
Oh.
The lot would get that serial
Your grievance is that you are not being heard, his name is being reflected in the revenue records.
In file, I have right, my lord. Apart from that, I have filed an implementation repetition also. But without even considering that, my lord, so impugn order was passed. So I have a matter of right, my lord. If you also be clear,
you have not heard.
No, my lord.
It was not he filed a petition for impleadment. He didn't argue the impleadment petition. He's not a party.
All right.
Now you have to come to page number 37, my lord.
37 of what? 37 of
Writ
what?
appeal, my lord. Main writ appeal. Writ appeal number 579, my lord.
Page 37.
37. It's a memo dated 5th November 2004, my lord. Now we had made an application for mutation for properties. My lord, in para number 3 of that memo, my lord, the lordship is 5th line, my lord, or 6th line. The special chief secretary and chief commissioner of land administration has stated that it is clear that no useful purpose will be served in pursuing those cases any longer, and also stated that there is no option left to the government except conceding the request of purchasers from the decree holder to effect mutation in their favor. So purchasers are on 2004 for the implead petitions only. Except then that no one else. Now whereas, my lord, petitioners hearing what the respondents here, my lord, they made the purchase of property much after this. So when the memo was issued saying that their names have been mutated, except for the implead petition, there is no one else, my lord. My lord, the impugn that today happened by virtue of serial number 12, my lord. Serial number 11, my lord. The lordship may come to page number 40, very next page, my lord. Next document. Serial number 40. Page number 40, my lord, 11. Next page number 39, my lord. Now the memo has been referred and mutation will happen subsequent to the name of the writ petitioner, my lord, under this document. Now the issue is, my lord, I have a 4 points last time I pointed in my written stuff, my lord, last page, 4 points. The lords may come to page number 6, my lord. These are 4 points I was canvassing, my lord. In fact, page number 7. Number 1 is I'm a prior purchaser. That's one thing I canvass. Number 2, my lord, I have a registered sale deed. They are a unregistered assignee, my lord, and which has been regularized. Regularized much later on, my lord, and the regularization of a sale deed can happen in a 5-way, my lord, not the assignment deed. Regulation is not permissible. Then, my lord, page 8 has it. Number 3. That writ petitions orders were suppressed in the writ petition. If the learned signature was brought as notice about the earlier orders and cancellation, inquiry, all things, maybe the learned would not have done it. 4th is, my lord, the mutation has been obtained by fraud because my memo was in my favor. That memo has been wrongly placed to service and obtained a mutation. That's my 4th one, my lord. And 5th, my lord, there is sale deed cancellation. What your lordship have said that whether High Court can do it or not. But if there is infraction of the rules, my lord, definitely this court can 226 can be done, my lord. That's a judgment in SK which is not their part of the judgment, my lord. In the case of ARCL, my lord.
No, but the rate petition was filed by him only seeking a direction for mutation of.
Mutation pursuant of memo which was obtained by fraud. That's what my grievance is.
Right. So we need not go into the validity of sale deed, whatever, and like this.
No, man,
Court is confined only to mutation.
but validity was already gone into by this court and a finding was given. That's what I wanted to be the lordship notice.
No, but what is this decision you are relying on?
Well, your lordship will pose the question whether High Court can cancel the registration or not. That's what your lordship had said. Then your lordship also said, even though it's cancelled, the underlying transaction is not.
Registration can be cancelled if it is contravention of the provisions of the Registration Act. What the query was whether we can set aside the sale deed. That is Satyapal Anand. Supreme Court.
This asset registration can then, in case if there's a violation of the statute in registering a document, that can be set.
Registration can be set.
Yes.
That's
Para 58, madam.
Para 58. Yes.
Last but one page, madam.
Yes.
It must be noted that when a High Court in exercise of its jurisdiction under Article 226 finds that there was actor failure on the part of the registering authority to stick to the mandate of law, the court merely cancels the act of registration but does not declare the very external document to be null and void. What your lordship had said other day, madam. Underlying condition is not. That's what it's.
Yes.
But a declaration that a document is null and void is exclusively within the domain of civil court, but it does not mean the High Court cannot examine the question whether or not registering authority performed its statutory duties in the manner prescribed by law. It is well settled that if something is required to be done in a particular manner, it should be done only in that manner, not otherwise. Examining whether the registering authority did something in the manner required in the law or otherwise is certainly within the jurisdiction of the High Court under Article 226. However, it is needless to say that High Courts may refuse to exercise jurisdiction in cases where violation of procedure on the part of registering authority are not crossed or the violation do not shock the conscience of the court. Lack of jurisdiction is completely different from a refusal to exercise the jurisdiction. In case on hand, appellant has not sought a declaration from the High Court that the execution document in question was null and void, or that there was no title for the execution to transfer property. The appellant asserted before the High Court only the act of the omission of the registering authority to check up whether a person who claimed to be the power agent had the power of conveyance and power of presenting the document for registration, especially in the light of statutory rules. Therefore, the learned single rightly applied the law and allowed a repetition filed by the appellant, but revision got carried out with the sanction. Now, in this case, my lord, 81 registered documents are in my favor. Registering authority, while having to look into this, my lord, I had to look whether there was registration or not. Already an inquiry in the 82 and 83 had gone into, and then when the High Court had said that already double registration is there, inquiry was ordered. Then the Inspector General had said that document has to be cancelled. These were not looked into at the time of petition. That para 61, my lord, the argument, then confusion ratio is laid down in para 64, my lord.
Yes.
But para 61, argument for advanced question whether the registering authority is carrying out administrative work or quasi-judicial act in performance statutory duties. But we think it is not relevant for determining the availability of jurisdiction. If the registering authority is found to be exercising quasi-judicial power, the exercise of such power will still be amenable to judicial review under Article 226, subject to exhaustion of the remedies statutory available. On the contrary, if the registering authority is found performing only an administrative act, even then the High Court is empowered to see whether he performed the duties statutorily ordained upon him in a manner prescribed by law. Then 64 is the rate. Therefore, my submission is, my lord, this is a case. One, having filed implementing petition, my lord, I ought to have been given an opportunity to be heard. Then, my lord, if I had brought to your lordship's notice before learned single judge, these are all the factors that 16 to 26 have been suppressed. Then, my lord, learned judge would not have, merely mutation may not confer a title, my lord. At the same time, my lord, we create a nuisance, my lord, for the purpose of possession. Because I am in personal property by virtue of 1981 onwards, there have been sort of litigations. So today, my lord, the mutation may have an impact on the, that's my submission. Suppression is a major key. That's what
yes.
Before learned senior counsel. These counsel are appearing for the same party.
I'll tell my lord.
Counsel cannot appear, my lord, for the same person. No, HAL Employees Cooperative Housing Society is their client.
My lord, before my friend begins, my lord, I'll just clarify so because there
is an objection, my lord.
I'm not saying, I'm not saying because I've already made my submissions. I've already made my submissions, my lord. When your lordship says that impeded petition writ appeal number 579, 579, my lord. The original impeded application was been filed by the then secretary, who was authorized person. Then person. Subsequently, because of issues, a person in charge has been appointed by the government. Person in charge. So he's no more the secretary. Therefore, I had to file a separate impeding application saying that the person in charge who has been appointed by government to conduct the affairs of the society, he has filed impeding application. I've also filed an independent writ appeal also, the person in charge before this on. My friend is appearing, person who was then the general secretary.
I filed the impeded application, the writ petition.
And counsel itself
there is a dispute, my learned friend has stated other day, Mr. Lordship recollects her name, the Amavataram. He is a person not having the authorization to represent on behalf of all who have been fighting this litigation.
No, my lords,
It's like same submissions. What is?
it's almost two facts, my lords. I may not take much time, just 5 minutes, because two other fraud claims.
Let him say something. You then answer comprehensively.
Only 2 points, my lords. I'll not go, because in addition to what my friend argued, my lords, these issue with regard to Novelos, I have filed a memo, my lords, of the documents. Lordship may take it, my lords. I may not trouble my lords on this, because they have played on the dead person name, they filed before this honorable court.
What is this?
Yes, it was. Yes.
Memo.
Fresh documents.
Like more than writ appeal paper.
Fresh documents.
No, these are
now in
fresh documents.
No, my lord. They are not part of this. My impleading application is allowed.
So, Mr. You understand rightly. Fresh documents you cannot file in writ appeal like this.
No, my lord.
This is.
These are the my lords, had the single judge my lords heard my arguments on the basis of this. This order could have not, my lords, today could have been under challenge. My respectful submission, neither the government
you were heard before the single.
What is my grievance?
What you also had filed an application for implementation.
No, I filed actually. In fact, I filed immediate application.
Society filed, my lord.
We both are selling together, my lord.
Society filed.
But is he correct in saying that both of you are appearing for same person?
For the same person.
Society, my lord.
For the same HAL
society.
Hindustan Aeronautic Rotary Society, my lord. At that time, his client was secretary. Now today, my lord, person in charge of the appointment for government, for him I am appearing.
So then, now what?
That's not only 2 points addition I'm saying. I'm saying with you.
You are the erstwhile secretary.
Yes.
What is
yes. No. The 2 points which are not.
You are not.
2 points which are.
You tell. Yes. Briefly, if you tell, don't pass on this like paper book like sort of thing.
Lordship, I look at page 197. The whole genesis of the my lords, the claim of the property on the basis of unregistered assignment deed. They, my lords, the vendor, the assigners, the legally is not made a party, saying that she has died. And the false death certificate fabricated. I challenge that, my lord, the death certificate, the special secretary, my lords, has ordered that is the fraud, my lord, stating that the person was alive. A death certificate is, my lords, created on this point. That is one aspect. Second aspect, my lords, they have filed application before this honorable court. Also, we look to page 229. One is 197 and 229. At 229, they filed application 193 of 2005 on the name of Sadachiv Reddy on 31st 12 2005. Page 229.
What is the point you are trying to except referring to page number? Please tell. You said 2 submissions. Tell us what are the submissions.
This is number 1 submission, my lords. Assignment date itself is wrong. First of all, it is unregistered assignment date. On the basis of that, they created a lot of documents and they made this.
All those questions are outside the purview of this writ appeal. We may tell you we are not going to give a finding that sale deed executed in your favor is valid and conveys title. Unregistered assignment deed does not. This is outside the scope of this intra-court appeal.
No, because
please appreciate we are only examining the validity of the order passed by learned single judge.
That's correct.
Learned single judge directs that order of mutation. In view of that order passed by the joint collector, his name should be mutated because that order binds the government.
No, that's
your grievances you have not been heard.
Yes,
that will be considered.
Had it been heard, my lord, this order could have not been there today.
So unregistered does not create any title.
That is unregistered and the parties, my lords, who have assigned us, the person is there legally will not made a party. I challenge the death certificate. Court held that the certificate is created by fraud. Number 1. Number 2, the filed application before this honorable court was on the basis of this. The Sadachiv Reddy, my lord, this application is filed on 31/12/2005. The time is not there, he has died. These 2 points, my lords, on the played on the court has been transferred on the registry.
All right.
And another point, my lords, I have filed a suit.
Who had died?
Sadachiv Reddy. Sadachiv Reddy, none other than the, my lords, the owner of this party who is claiming the title now, who is the respondent here.
It's a company, not a party.
Company. He was the managing director, signed by the Sadachiv Reddy, my lords, approved before this honorable court. On behalf of the company, person signed, the date he signed is not alive.
So all this you should make an application, Mr. This is not an argument like this.
My impleading application is pending, my lords, because unless I am impleaded, I can't put forth all these facts. My grievance is, Lordship, my lords, I have been.
Also, affidavit signed by a dead person. Huh?
Yes.
You see, this is a missing date in the register. Executed lady, facility. Please, you should take number.
Who had shown them the affidavit in the writ petition?
In the CS 14, they have filed application, my lord, that is page, that's the reason. Page.
No, in writ petition when they filed the.
Not writ petition.
Then?
In the application CS 14, they filed application on 31st/12/2005, which is on page 229.
This is not CS, Mr. This is writ petition. This petition arises from an order passed by the single.
This application only they are claiming the title source. Because the whole genesis of the base document itself is wrong. Now they made up this constitutional court as a civil court deciding the title.
That nobody has decided. We have, you are not aware perhaps of the judgment. We have delivered two constitution bench decisions of Supreme Court have held that questions of title cannot be repeatedly we are telling you we will not heed. We told him also, and this thing, it's a question of mutation. We told him also, you are arguing so that to invite a finding on question of title, you want this court to hold that his unregistered assignment deed does not create any title. I have a registered sale deed, society is the owner, therefore society's name should be mutated in the revenue. This is what the order you want.
I'm conscious about my lordship's order, my lord. My only respectful submission. Once mutation is done.
We will not go into this question of title, Mr. This is an intra-court appeal against order passed by learned single judge. Scope is only confined to examining validity. You should have been heard. That's a valid point. Then it's a fraud and this all cannot be decided in a writ petition.
No, today, my lords, my impleading application is pending, sir. That's the reason I could not file all those documents along with my implead application. So, lordship, I have been requesting.
So we will grant you the liberty to prosecute them in an appropriate forum in case you feel.
Once mutation is created, my lords, equities are created, a lot of.
We don't know what order. We have to hear it.
Yes.
His grievance is justified that he has not been heard except him, everybody.
In the last time you said.
Overtaking. Yes. No, but what happens that the one who you will speed up and overtake eventually all as they come to finishing line.
Last point. This honorable court in the writ, my lords, one of the writ asked I given a direction to cancel the sale deeds. They sold it. This is still writ is pending. In contempt, they have been punished. Registration officials.
Sale deed, this is an unregistered assignment deed.
No. Basing on unregistered assignment deed, thereafter they entered into a registered sale deed.
Mr. We don't want to go into all this, Mr. Again, we have told you that the scope is confined only to examining the validity of the order. Learned single judge, we will not, we cannot go beyond the two decisions of Constitution bench of Supreme Court.
No, but there is a serious fraud. Once fraud issues, everything lordships are aware. We are on the point of myself.
So we will say the fraud, you did not say what fraud played. What was the fraud played? You said everything except what is the fraud? Who had died? On what date he died?
I filed as well as all these documents.
Who died?
Mr. Sadashiv Reddy.
Who is Mr. Sadashiv Reddy?
Sadashiv Reddy is the director of the managing director of the persons who are claiming the title Vedre Estates.
Managing director
of the Messrs. Vedre Estates, who is petitioner in the writ petition.
Managing director of petitioner company.
Yes.
All right. So what happened?
I filed a death certificate. He died on 16th August 2004. 16th August 2004 at page 247.
Acha, he died. Then what happened?
Then my lords, on the name of the dead person, the affidavit is filed before this honorable court on first.
No, where, who filed affidavit?
The Saraju Reddy.
No, which, in a writ petition?
Not in the writ petition. Not in the writ petition.
Affidavit was filed where?
In the CS 14, my lords. Application 193 of 2005.
CS 14 of 1958.
Yes.
When?
That is on 31st December 2005.
31st December 2. What is the affidavit?
That is application number 193 of 2005. Page 229.
193 of
2005.
What is the application seeking?
Application, my lord, they are asking for the return of the original sale deeds from the court.
So,
no, this is the part played on the court, number one. Number two, my lord, earlier, that is the assignment deed where the legal heir is not brought on record saying that she has died. But she was alive. The certificate is, my lord, by order of the secretary, it is being cancelled. And third, my lord, this honorable court has passed the direction to cancellation of registered sale deeds. Their sale deeds. They don't have any title. I am 1981 owner. Well, this is the 3 points, my lord.
All right. Thank
and another issue, we are in the possession of the property. We got the injunction from the court.
He is saying he is in possession. You are saying you are.
We both selling. We both.
Everybody, we will decide whether Mr. Venkatesh or you, and whether he or government.
We both are selling together. We both are selling together.
This is not the possession, etc. is wholly irrelevant to according to us.
By virtue of order in OS number 350.
No, you be in possession. We are not passing any order disturbing your possession.
I mobilize.
Yes. Yes, Mr.
Mallet, I will formulate my contentions, Mallet.
Yes.
First contention is, this is an intra-court appeal.
Ah.
Scope of the intra-court appeal has been very well delineated by the Supreme Court. I'll give only one judgment.
All right.
2018.
2018.
Volume 17. Supreme Court cases, page number 106, paragraph number 3.
All.
That is, the correctness of the judgment will be gone into very well settled proposition. I am also passing on the same judgment before the honorable court. So the scope of this appeal filed by the state is extremely limited.
Yes.
And writ appeal scope cannot be enlarged by persons who were not there before the learned single judge.
Yes.
If their remedies are available in law, they have to take recourse to those remedies. Then, Mallet, your lordship may kindly have a look at this synopsis which I have passed on to the honorable court only on 2 points.
My brother has some query. Please answer, Mr.
Sir, since these matters now we are hearing should be considered as a civil court or an intra-court appeal. Because unless
this is a writ appeal, Mallet, arising from an order of the writ petition. This is, if it is CS 14, this court is civil court as well as appellate. Mallet, CS 14 is a suit filed in the district court withdrawn by the High Court under section 24. Therefore, this court is the original court. In fact, this court does not have the original side civil jurisdiction as far as the rules of the court are concerned. These are specially at that time, Mallet, in 1958, the volume of writ work was very less. And these civil suits of these particular persons, very few, 4 of them, were withdrawn from the district court. Now I am only making submission in the writ appeal number 579 of 2016, which the state has filed. And in this particular appeal, the scope of the appeal I am submitting, my lord, it is an appeal filed under clause 15 of the letters patent. It is an intra-court appeal. Present appeal is directed against the learned single judge, and order of the learned single judge is when the statutory authority has granted mutation in favor of A, my client, then that has to be reflected in the revenue records, which the rule itself, the section itself says.
Any final decree has been passed in subject property. This subject
That is over in this case, my lord, the sale deed subsequent purchaser, my lord. This is not party of CS.
Any final decree has been issued to the.
Yes, final decree was passed. Thereafter, it is sold again in 2005. That is my synopsis first item. Well, it is not, it's not a, well, your worship may kindly see, my lord.
Where is your synopsis, Mr.? You gave it on.
My synopsis, my lord, is part of the court record. I have given 2, 3. It is in.
Like this?
Yes, that's all. Right.
Yes.
2 page.
Ah.
Item 1, your worship may kindly see. 10/6/2005. The petitioner purchased the subject land. He is a purchaser from persons who are parties in CS number 14. Has purchased the subject land in survey number 77, Hafizpet village. The said sale deed gives the flow of title of the writ petitioner. This is the beginning. Then, on the basis of this particular sale deed, the writ petitioner had applied for mutation under section 4 of the Record of Rights in Land and Patadar Passbook Act, which I have passed on to my lords with the text of the statute.
Yes.
Under section 4, I have to intimate to the recording authority I have acquired a right by way of sale or succession. Then the recording authority, my lord, will inquire and then he will pass an order. And under section 10A of the Act, the order, my lord, has to be implemented. The order has to be carried out in all the revenue records. Section 10, capital A of the same Act, 1971 Act, which was the Act at that particular point of time. My lords may kindly see, my lord, section 10A, corrections to be incorporated in the village revenue records. After the final publication of Record of Rights in the manner prescribed, the Mandal Revenue Officer shall take action to incorporate the said particulars in the village revenue records, subject to the amendments as may be necessary on appeal or revision as the case may be. This is the statutory provision that when once a mutation, section 4, my lord, your lordship may kindly 4 and 5, how this statutory exercise is discharged in this particular case. Section 4, my lord, is about any person acquiring at page number 5, my lord, of the statute book, internal page 5, middle, section 4, after section 3A. After section 3A, which is in bold, there is section 4. Any person acquiring by succession, survivorship, inheritance, partition, government land, decree or otherwise as a owner, patadar, mortgagee, occupant or tenant of the land, any person acquiring any right as occupant by any other method may intimate in writing about the acquisition of the right. This is the intimation. Enquiry made under 5, section 5. Then order will be passed under section 5, subsection 4. Section 5, subsection 3. The recording authority shall, before carrying out any amendment, etc., issue a notice in writing to all persons whose names are entered in the record of rights and who are interested or affected by the amendment to any other persons who one has reason to believe. Then subsection 4, every order passed shall be communicated. Then, my lord, there is an appeal under section 5.5. There is Section 5, subsection 5. Now, my let's kindly see section 9 is the revisional power. Section 9 is revision. The collector is vested with the revisional power. Now, my let's kindly come back to my synopsis. My sale deed is 10/6/2005. On the basis of the sale deed, I have applied for mutation. On 14/11/2005, item number 2, the Asildar has passed orders granting mutation. Nobody has challenged this order of mutation. The council argued loudly in the court today that there is fraud, my sale deed has been cancelled. It was very simple for them to challenge the mutation that has been granted in favor of the writ petitioner. Firstly, on 14/11/2005, but this 14/11/2005 at serial number 3/6/2007, the mutation order dated 14/11/2005 was set aside in the revisional jurisdiction by the collector. Then I come to this honorable court by way of a writ petition, which is item number 4. 15/12/2008, the writ petitioner has challenged the order dated 6/2/2007, and the writ petition was allowed, setting aside the matter and remanding the matter back for fresh orders. Then at serial number 5, 6/5/2009, after remand, the Joint Collector Rangareddy District passed orders granting mutation in favor of the writ petitioner and directing the Tahsildar to implement the same. Thus, the petitioner has title and mutation in respect of the subject land. Then 6, the petitioner requested for disclosure of the mutation granted to it in the revenue records. Since the said request was not acceded to, the petitioner has filed the writ petition, WP present writ petition, with the following prayer. Direct the respondents to incorporate the name of the petitioners in respect of the land in all the revenue records. Learned Single Judge has granted this particular relief. I have also mentioned here in this particular note, next page, paragraph 11, it is settled law that mutation does not confer or take away title of any party, which is 2014 2 SCC page 269. So now after this order of the learned single judge directing implementation of a statutory authority's order in the revenue records is challenged by the state in the writ appeal 579 of 2016, which the Additional Advocate General has argued. The learned counsel who have argued, two learned counsel for the HAIL Employees Cooperative Society, they are having an independent claim, they do not have any order of mutation. They have not challenged the mutation order of the writ petitioner in any forum whatsoever. Having not challenged the order of mutation in favor of the writ petitioner, which is dated 6/5/2009, it is not open to them to contend in this intra-court appeal the various alleged infirmities in the title of the writ petitioner or about the grant of mutation. Well, they have remedy. They have remedy in law, not just getting impleaded in my writ petition. They have an independent right to challenge, which they have not exercised. And another thing, my lords may also kindly appreciate that they have not so far referred categorically as to when they have applied for mutation in respect of their sale deeds and whether their mutation claim has been accepted or rejected. This is conspicuously silent in their argument. They have not challenged my mutation. They have not been active to obtain mutation for them. They are arguing about my title, which is totally outside the scope of this writ petition. Question of possession is also outside the scope of the writ petition. And the learned Advocate General, as I understood, said that the mutation will be done in favor of the writ petitioners, subject to the result of CS number 14. In the last occasion, he said so. Today he is asking for passover. At any rate, now the reflection of the names of the petitioner in the revenue records does not in any manner take away anybody's right to the property. So the order passed by the learned single judge, unless the order is perverse or the judgment is erroneous. But in an intra-court appeal, the honorable court may not interfere. This is my submission.
May I circulate the copies of the Dharani?
2:30.
Yes.
Where is he?
2:30 minutes. 2:30.
So we will give him 10 minutes.
Yes,
That's it.
Yes,
All right.
Item,
2:30.
item number 32 is my independent writ appeal. I can say independent writ appeal. What the learned
Against the order passed in his favor. All right.
one is impeding which is IA 32 malad. In writ appeal is 33. But same points are same malad.
Yes.
Only to answer this malad. Mutation has been ordered in my favor independent in 2004 malad. That's one thing. Which I must already see that page number 2004 malad.
Yes.
At page number 3 you must already see. Second point is malad. Entire suppression has not even, just because even though it's intra-court appeal, the suppression, what happened, transpired in between has not been dealt with. Not been dealt with. Third is this, the mutation order of 6529 has been passed on an invalid document. It's a fraud. That's the one.
Yes, we'll take it up. Give him 10 minutes, Mr. Ask him.
Yes.
Just by way of a reply. He has already finished. Since it's your appeal, therefore. 2:30. Yes. Send this right. We'll dictate one on and send. Yes. 33. Yes. There is 2003 writ petition. Yes, you are appearing.
There is item 34, my lords. I'm appearing. Item 34.
What is 33, Mr.? All right. 33. So they are all interlinked, right?
Yeah.
Yes. What?
I'll be making my submission writ appeal 508 of 2011. It's
So these all these matters can be decided by a common order, right?
Yes, yes.
518 of 2011.
508.
508.
It's against the orders passed in WP number 7716/2007. The declarations were subject matter of CC Minot before the authorities. There were 5 declarants of one family Minot. In respect of 3 of the declarants, the proceedings have attained finality because they have not been appealed nor before the High Court.
So what are the facts? Please tell us.
But kindly go to at column number 4 and 5. They are the writ petitioners before this one. I have given that list. Event-wise details, the sheet.
Event-wise details.
So 4th and 5th before my lords are for the Honorable High Court in writ petition. They are before the authority. They are before the authorities and also before this Honorable Court, challenging these surplus proceedings declared, land which was declared as surplus as against them. In pursuance to a declaration filed, 8-1 notice was issued, 8-4, then after 9 orders were passed, then 10-1, 10-3, 10-5, 10-6, according to the state has taken possession on 4-11-99. But I have to state certain things, there are several writ petitions which were filed earlier to this. Earlier to this writ petition, where the impugn order was challenged before the learned single judge. Earlier to this, there was one writ petition, my lord, your lordship will kindly go to the book, my lord, which is before my lords. Volume before my lords, but which deals with that is WP number 18851 of 2003. 18851 of 2003. My lord, I have the volume, if your lordship go directly to the volumes, my lord, it's a fine.
Wonderful. Which volume?
It's a big book, perhaps. It's a book, W number 508 of 2011.
Oh, we have 508.
Same book. Your lordship's
Which
guide.
page?
Page 139. My lords are having the same book, perhaps. 139.
One 18851. Read petition.
Yes. This was a writ petition which was filed by the declarants, challenging the proceedings were not issued by the authorities, holding them to be surplus landholders to the extent of two different extent were not held by petition number 1 and 2. Lordship, kindly go to the prayer in the writ petition. 143 is the prayer. May I read this, Brad? Honorable Court may please to suspend the operation of the order, second respondent appeal number so and so, including the order of the third respondent and notices under section 10(1), dated 18/5/94, 10(3), 10(5), the ULCR in respect of properties held by first petitioners also, proceeding number so and so, notices under section 10(1), 10(3)(5), of the urban agency in respect of properties held by the second petitioner. But this was the subject matter of challenge before the Honorable High Court earlier. But this writ petition came to be allowed by the learned single judge by an order dated 8th of August 2005, which is at page 154. It starts at 154. Referring to the declaration that the appellate orders passed at 156, if your lordships come, 156. The learned judge, while considering the arguments advanced, but the third line, the order passed by the special officer in 156, right? Third line, the order passed by the special officer competent authority came to be questioned by the petitioners for filing appeals before the commissioner appeals. The learned appellate authority dismissed the appeal on the ground that the entire area is covered by status quo orders. The matter is pending before the High Court, and therefore he cannot adjudicate the matter till disposal of the case by the High Court. Heard the counsel for the petitioner, learned government freedom of kind. The learned counsel for the petitioner submits a number of writ petition which the status quo orders have been granted is not mentioned in the impugn order as such to the knowledge of the writ petitioner. This is the contention of the petitioners. There is no order of status quo granted by this court. In any writ petition in which the case, the appellate authority has to consider the objections raised by the writ petitioners, the grounds of appeal and
So from this order, this writ appeal arises. What is it? This impugned order.
This why I am reading this, Bharat. This order was, this writ petition was allowed at the instance of the
See, still, you have not told us the facts. They obviously they held lands within urban agglomeration. Therefore, proceeding were initiated and order was passed. Must have been passed by competent authority upheld in appeal.
Yes, sir.
These are Mr. Prasad. These are final hearing matters. We don't read it, but you have to give basic facts like so. The order must have been upheld by appellate authority. They have challenged in a writ petition. What has learned single judge done? Yes, he must have said that position is not taken.
But in the
right, therefore repealed. Something like that. What is done?
The event wise not have status. I'll just read.
No, you tell us what is.
17 to 1993, after following the due procedure laid down, inspired SO and ULC otherwise passed order in 84 of the ULC Act, duly determining the reclaimed surplus holders to the extent of 18,375 square meters and 20,368 square meters respectively. Aggrieved by the FCORT orders dated 17 to 93, the following to declare as a preferred and appeal under section 33 of the Principal Act before the appellate authority, Commissioner, against the orders of the Professor of the Competent Authority, Hyderabad, the details on. However, it is next, the appellate authority has passed status quo orders as on in appeals of 76 of 93.
Status quo. Dismiss the appeal.
Yes.
1512.
Yes, sir. Appeals were dismissed. As against this, my lord, I was reading the order passed in the by Learned Single Judge here. Just
Allow
now,
the order. Read petition.
Your Lordship sees the serial number 13, my lord. Agreed by the above said orders 27/6/2002. The appeal number so and so. WP 18851 of 2003 before this Honorable Court. The Honorable High Court orders as follows.
This is the problem, Mr. You this thing properly don't staple the page. 1, 3 and page 2 is there after. We are looking.
1 and 2 is, I'm reading the second page. My apologies. At serial number 14, the requisition came to be allowed. My lords are already in the same page, serial number 14. Matter is remitted back to the appellate authority for disposal afresh after hearing both parties. However, it is further made clear the status quo existing as on today shall be continued. That was the order passed by the Learned Single Judge. This is on 8/8/2005. Thereafter, my lord, an appeal 59 of 2005 was filed by the declarants before appellate authority after the remand. The appellate authority was pleased to dismiss the appeal on 15/12/2006. Agreed thereby, my lord, the requisition was filed which came to be allowed, as against which the present appeals are being filed.
So what is the?
But I was reading the order of the Learned Single Judge while you were remanding back the matter. If your lordships kindly again go, my lord, to page 1.
That was first round of litigation.
Yes. First round. And also they
So is
corrected
it necessary? But why? I mean, is it relevant? Like.
But since I've read the prayer, my lord, they have challenged the declarations earlier. Notification, gazette notification issued under 10.1, 10.3, 10.5, 10.6. And kindly see the order now of the Learned Single Judge at page 158. While the state was also containing the status quo order, finding of fact was there was no status quo order and the requisition came to be allowed and the matter was remitted back to the authority. May I read 158 words? It is explicit from the above referred order that we have the status quo order said to be granted in requisition if appeals are dismissed. Neither the requisition number nor the date of order passed by the High Court is mentioned in the impugned order. Specific assertion of the petitioner, no such order has been passed by the High Court to their knowledge. Even the government of assignment appearing on behalf of the respondent not in position to say the WP in which the status quo order has been passed granted by this court. In such a situation, the matter needs to be remitted back to the appellate authority for proper consideration of ground. It is allowed, so the order is set aside, matter remitted back. And if your lordship now go to 59, page 59. The authority has considered, madam. Page 59. This is in pursuance to the remand order passed. By recording the various contentions, if your lordship kindly go minute to page 62. In pursuance to the order of WP number so and so, notice was issued to the finance attend for hearing on so and so date. 21/12/2005, impleading respondents 2 to 15. These are the societies which got impleaded before this court, and they were before the authorities also. Impleading them as respondents above appeal, the main and similar grounds they have purchased the land from the owners for a valuable consideration, registered sale deed, further represented that they have paid the requisite amount on the GOMS 455 for regularization of land with payment of rate fixed by the government. Case was called on so and so date. Filed a petition requesting for adjournment of the case. Case adjourned to several dates. Nobody appears. When an advocate filed a Vakarat on impleading petition, then the fact, if your lordship sees, on behalf Tirumala Society, last slide, Tirumala Venkateswara Cooperative Housing Society, which was one of the purchasers from the declarant. What I was trying to, they have already alienated the property in various societies. The societies were before the state requesting for regularization 455. That was a policy decision of the government upheld by this court. That was considered, land was regularized in their favor, but no orders were passed because the status quo granted by this court. That is how the matter was proceeded with. But the specific contention of the petition is that no notice is issued and also they were not heard. In the earlier orders after and the lands did not vest with the government. No permission was taken. That was the contention of the petition. So lordship now go to Marat. The order of the appeal. Not only that position was taken, kindly go to page 70, page 70, in the very same order. There is the correct 70.
So what are your submissions? Tell us, then you can elaborate. You are reading here and there. What are
my submission?
What has learned single judge held?
But by submission, I have heard.
No. What has learned single judge held?
Yes, allowed
the petition, fine, but why?
Allowed the petition.
They have not been heard.
They have been heard. In the writ petition they were heard. Writ petition was allowed in their favor, holding that the.
No, why it has been allowed? That your note doesn't say why it has been allowed. It only records a conclusion. So why the writ petition was allowed by learned? You tell us, Mr. John. Not ready. No. Really?
Right. So please go on the impugned order. How you are agrees with that? Because the
What
act
has learned single judge held? Why he has allowed the writ petition?
Just page 23. Page 23. No record has been placed to show that notice of opportunity was given to the petitioners at the stage of proceeding initiated. Page 23. Read that as well. Page 2-3.
Why clean alone? Very clean. Notices were served.
But page 2-3. Last paragraph. Last 2 lines. Be that as it may,
1 minute.
no record has been placed to show that a notice.
Really finding. It seems that during the pregnancy, we have to increase. That's right. This is what we keep finding. He is not ready. Yes, sir. So come to page 30. We hope that you have must have read the order. Yes. By. Why you are page 33?
Yes.
Read
Panchnama drawn inspector.
You will get the reasons why it has been allowed.
Mention where possession or extent of so and so meter of structures taken. No notice was issued to the person who has found the structure. Even before taking Panchnama, land is to be identified as subdivided. There is no subdivision except in mentioning in the printed Panchnama. No subdivision numbers were assigned to the survey number. No record is placed to that effect. Written from the proceeding that no proper notice, no opportunity is given at the stage of proceeding on 10-3, 10-9, 10, 10-3, 10-5, and 10-6. Taken during pendency of salutary appeals. Get respect. Therefore, in proceeding become. But this period I was answering to my lord only one aspect. Respect with regard to notices not being given may not be correct. Lord, I filed a counter. In the requisition itself, counter was filed.
No. Therefore, we asked you why learned single judge is allowed the writ petition. You are unable to tell us.
Only on the ground that the Panchnama was drawn and also the notices not have been given to the petitioners. At page 23 minutes, the learned judge deals
notice with of what has not been given. This all the pages from 9,
23,
section 9.
No, 23 if you not just page 23 para. Page 25, last two lines. Page 25, last two lines. Be that as it may, no record has been placed to show that a notice or opportunity was given to the petitioners at the stage of proceeding incident 9, 10, 10-3, 10-5, 10-6 of the ULC Act. This I was explaining to my lords. Kindly, if your lordships go to the counter at page 23, counter which starts at page 232, page 232 by the.
No, forget counter, Mr. What is the record? You are ready with the record.
Yes.
Produce it to show that it has been served.
I'm just trying to say, I've stated in the counter, RPID notices were sent and also that they were heard. RPID, the registered court, kindly see. Page 232 is the counter, 232 filed by Secretary to Chief Commissioner. Relevant portion is page 238, para 7. That's a counter file in the requisition. Reply to para 14, respectively submitted. Case was called on 22/8/2006. Client was not represented to any counsel, said General Emma, who previously represented his case in file number also prior to remand of High Court, voluntarily came back forward to contact the apparent, obtain information regarding counsel to represent the case or otherwise inform this court before next counsels for impeding respondents are present requested for dismissing the appeal. The appellant is not pending up for hearing. Case was adjourned to 14/9/2006. Orders were thrown on 15/12/2006. The contention of the appellant that the order was passed without giving intimation to them and subsequently dates is not clear. The appellant are informed of the dates hearing from registered post. Kindly see the date of hearing and date of registered post sent to the petitioners. But these were the dates when the matter was posted on different dates. Matter was heard for appeal, order was filed in appeal. But why I was bringing to my last notice the earlier interpretation order is they challenged the 10.1, 10.3, 10.5, 10.6 notifications. Where vesting was there, 10.3 land were vested in the state. Subsequent thereto, the order of remand was only maintaining status quo. Status quo in regard to possession and the appeals to be heard afresh. Again, the appeals were heard afresh, dismissed, appeals were dismissed. The notifications which were challenged earlier, though the United States heard the information, notification was not set as scratched. Only the order which was passed as competent appeals was set aside, but were remitted back to the extent of hearing them on weight regard to possession. Kindly see the order subsequent. Now, writ petition file which is now filed before the United States, single judge, the prayer you have to see. Page 36 is a writ petition, writ affidavit. Page 57 is a prayer. 57. May I read the prayer? Therefore, may this honorable court may please to page 58, 57. Last three lines. Please to issue a writ order. Direction mode particularly on the writ of signatory, call for record dating to and connected to the orders of the first respondent and appeal, covering both the orders. But why I am bringing to my notice is the declarations which were earlier challenged by the writ petitioner, the learned judge was pleased to grant relief to the extent of not remitting the matter to be heard afresh by the appellate authority without setting aside the declaration. Notification issued under 10.1, 10.3, 10.5, 10.6, where possession was taken by the authorities on 4/11/19. But that remained, those declarations, the notifications remained as they are. The authority was directed to consider with regard to the fact that notices were not issued and they were not heard properly. Subsequent thereto, the appeals were filed in appeal 59, which I paid 59, it was heard. Again, the appeals were dismissed, came to be dismissed. Kindly see the fresh writ petition which is filed also. Nothing about the notification at all. Only the prayer is to set aside the order of the appellate authority. Vesting has become final. Vesting, so far as the lands which vested in the state in 10.3 has become final. But thereafter, why I am saying all these things, several alienations have been made by the writ petitioner's family in favor of responding societies. Societies came under 136 GO of 1981 before the government, seeking regulation of the land of 455 GO, which was in vogue, is still in vogue, which is confirmed by this dividend bench of the honorable court as a policy.
You have not mentioned all these facts here, Mr.
I have said so.
If only your lordships permit me, Lords. Page 18, if your lordships will have page 18 just for a moment, Lords. Whatever my Lord colleague is saying, Lord, is all the historical past. That's no longer relevant. While the repetition was pending, Lord, before this honorable court, the Repeal Act, your lordships are aware about the Urban Land Ceiling Repeal Act. The Andhra Pradesh government notified its applicability in the state of Andhra Lord in 2008, April 2008. That is the time the petition was pending. So, lordships will see page 18. The learned single judge takes note of that, my lords, obviously on our submission. And therefore, the only question, my lord, which fell for consideration was this, whether position has been taken or not. Lordships are aware, my lord, have dealt with any number of decisions, my lords, in different courts. So, my lord, for the purposes of the saving, my lord, the finding of the learned single judge for innumerable, my lord, number of reasons, my lord, is this, that position has not been taken. There was no notice in accordance with section 10.3, 10.4, 10.5, 10.6. The records have not been produced. Panchanama is of no authenticity, my lords. It's a cyclohistoric format. It seems like a paper petition, my lord. and physical possession is throughout with the petitioners. On that finding, my lord, the Repeal Act has been applied. And my lord, it has been declared that the entire silly proceedings, my lords, have abated. That's the short of the matter. So, my lords, going back to the earlier orders and all this, my lord, are no longer relevant.
That would be relevant for, as far as state is concerned, I was just trying to put it across for my lord's consideration. But why I am saying so is that the earlier notifications have not been settled, not with the learned single judge. Learned single judge remits it back to the authority to consider afresh in appeals.
What is the effect? We have not seen this act for a long time now. So what is the effect of repeal act? Tell us. What is the, after remand, the only, this thing after repeal of the act, the only relevant criteria would be whether possession has been taken or not.
My case is.
So you produce the, you show from the record that possession has been taken. Why it has been disbelieved?
My case before the authority, before this court was, I have taken possession of 41119.
That's why we are telling you that you should have told us the submission, Mr. Prasad. What I mean, we don't know what manner you are arguing.
41199 is a position.
So what are your submissions? Now tell us.
My submission would be, much prior to the repeal act coming into force, possession was taken by the state. 41199 is our date.
41199 possession taken.
Was taken. But I have also brought to my lord's notice, my lord.
Possession taken on
41199.
41199. Then what is the other submission?
This is much prior to the repeal act.
Fine.
But I was bringing to my lord's notice, my lord. That is why I was bringing to my lord's notice the notifications which were issued by 10.3 minutes. Your lordship kindly see 10.3 minutes of the act. But 10.3 minutes, the land.
That we have noted. You tell us submissions, then you can elaborate, right? Notifications under section 10.1 to 3 have not been.
10.1 to 10.6 have not been set aside by this court, excepting remitting the matter by learned single judge to the authority to decide afresh in appeals with regard to the computation of the petitioners. But there were originally 5 declarants, only 2 are before the court. The rest, which 96,000 square meters are concerned with, that vested in the state, because that is not the subject matter of dispute at all.
No, not set aside means so.
That is not subject matter of dispute at all. Only 2 of the declarants from the family are before the court challenging 10 extents allotted to them. I have given in the note also 18,301 square meters and 20,368.
One.
Minutes. 10.3 minutes.
So, Mr. C, section 3.2. So land may have been vested, right? Yes. Under section 10.1, 2, 3, whatever, 10.3 property, it vests. So, but so what is section 3.2 of repeal act?
Yes.
Where any land, clause A, read clause A.
But the vesting of any vacant land under subsection 3 of section 10, possession of which has been taken over the state or any person duly authorized state government in behalf.
No, 3.2.
3.2. Any land is deemed to have vested in the state under subsection 3 of section 10, with the principal act, but possession of which has not been taken over the state government or any person duly authorized by the state government in his behalf or by a competent authority. Any amount, that such land shall not be restored unless the amount, this will apply not in case I don't take possession. Here I have taken possession.
So therefore, the senior counsel is correct in saying that the only question is to be examined is whether possession has been taken on, according to you, on 4/11/99.
Yes.
So why you must have placed all these documents and record before single judge. Despite that, single judge, why he has discarded, that's the only thing.
Pancharama, your worships, I have related to my lord, your lordship, I have directly pointed out but saying that the Pancharama mention.
Correct. Now the only dispute is under section 3.2.
Yes.
Under section 4, all proceedings abate. So the only thing which survives is possession.
Yes.
If you have taken possession, I mean, then there's no question. If you have not taken, the land will be restored.
But one aspect.
Right?
Yes.
This is the question.
Yes.
Ah.
The possession.
Tell us
I'm
possession.
relying on the possession aspect to show because I have parceled out the land under GOS 455 to various societies who had purchased under agreement of sale from the petitioners. Having seen since the documents are hit by subsection 3 of section 5 of the ULC Act, pending proceedings, the petitioners are also not entitled to alienate. Therefore, they have opted for benefit of 455 for the state. State has conferred that right by collecting the sums which are prescribed under the GO, and the possession is in fact under.
What is GO? What I didn't get it. What is the
Issued exercising power under 23 of the Act.
No, first, Mr. We will go to whatever GO and all that, but you tell some. First is we have understood that 4/11/1999 possession was taken.
Yes.
Then you have told us that notification under 110.10.1 to 3 have not been set aside, and
Matter was submitted back.
remitted only to examine.
After remittance, if your lordship sees the order at page 59.
No, submission. Then we will go to page 59 and everything.
After remitting back to the authority, authority issued notices, heard them on merits, dismissed the appeals, confirming the earlier orders of declaring the land should be vacant.
Yes.
But thereafter, when the present writ petition came to be filed, the learned judge now recorded the finding that the Panchanama is not properly drafted and no notices are issued. I brought to my lord's notice that RPAD notices were sent through my counter which I filed by the secretary at page 238, and possession.
This before taking possession was given.
Yes, notice. I just pointed out to my lord. Registered post acknowledgement due. The lordships again go to my lord, page 238 of the paper book.
No, you first broadly tell us submission, then you can elaborate.
Yes, notices have been given under registered post acknowledgement due on various dates, indicating the various dates of hearing of the appeal. Subsequently, orders came to be passed, final orders came to be passed with the appeal, determining the surplus to the extent of 18,000 and 20,000. Two different declarants. Subsequent thereto, my lord, the state issued a GO.
So these are three submissions, right? One, that possession taken on 4/11.
Yes.
Notification under 10.1 to 10.3 not set aside.
Yes.
And notice before taking possession sent by registered post.
Yes.
Now you can elaborate whatever way you.
One more aspect is,
so where is the document to show that possession taken on 4/11/99? And when was notice issued prior to 4/11/99? Record
is here.
Find out where is that. Tell us when was notice given to them and who has signed. Like Panchanama is not signed by anyone.
The record which is with me,
whatever.
411 Panchanama is original. Panchanama is also here.
No, but tell us when did you issue notice? You just now said that notice was issued. What date notice was issued? What is the material? Like, are you relying on presumption or there is an acknowledgement?
It's in English and Telugu. One second, I'll take some time.
But original
31/8/99 is the one. 31/8/99. 31/8/99.
31/8? What 31/8? Notice?
Yes, under 10/5, 31/8/99.
10/5? No, notice before taking possession you said was given, no?
It's given.
When?
31/8/99. This is 10/6 note.
One. So 10/5 you are required to give notice, right?
Yes.
So when it must have been issued in October sometime.
15/7. 15/7.
15/7. 99.
57/98. 10/5. 31/8/99 is 10/6. 10/6.
It says you are 15/7.
57/98. The record show. 10/5. 10/5. And
Where is that? Put a flag and give it. There are 3 notices according to you. 15/7, 20th October 1998, and which is the 31st August. No. Notice 15th October 98 and 26th October 98, right?
August.
August.
Not distributed. The challenge is
In synopsis, you have given 2 dates, Mr. of notice under section 10(5). One is 15 July, other one is 26/10. Correct. See your synopsis, second page.
26/10 is also.
These 2 notices you have mentioned, no, in synopsis. Please see your synopsis, second page.
Yes.
And he will show us. He will.
26/10.
So put a flag. Where is that in the record? Show us when it has been served. Who has received it?
May I just.
No, but please tell us who has received this notice.
Received copies done by initial file level entry.
Please see. Bali.
Yeah.
It has been received by somebody, right? Who?
Yeah, registered.
See.
When notices were challenged by them, they are not disputed. They have challenged it.
Challenge?
They have challenged the notice.
Where? In the rate petition?
Very 18851, they challenge it. 10/1, 10/5, 10. Which were not set aside by this court.
Especially but especially responding to me. See this is not to it is 26 you know the problem. Ending the games of nothing I sweet of potato. The river is the crash. They keep talking. Let's see whether we have to resume the expect. And where is the other notice?
Totally 6 notices, right?
Not six, four are not agreed, four are not agreed, 5 and 6 are agreed. Before the authorities, before this court. 2 extents are only subject matter of writ petitions. Last 5 and 6.
No, but go to page 181.
Minutes.
The name is showing as Natwar Lal Mangal Das Patel. Is he a respondent in this appeal?
180.
Panchnama, that's Panchnama, 181.
Yes.
Where position was taken under section 10(6).
Yes. Yes, ma'am.
This is October, Mr.
This is the land merit which is 96,347 square meters or 479 square meters. This one, the reverse page which I pointed out to my daughter in the Panchanama, but this is not subject matter of dispute at all. This is in government possession. What is now the subject matter of dispute is 18,000 and 20,000, 2 different extents of 5 and 6. 5 and 6 only. Total extent is 1 lakh odd owned by the family.
So that copy is not filed in the material papers.
Which copy?
The Panchanama, what you are saying.
It is here.
This Panchanama, you say it's not concerned.
It is 6 others. Out of this, kindly, I'll explain that. Out of this merit,
What these people? What does this mean? No, this much. I'm saying with the appellate. Others have accepted, right? No, the petitioners, like we sent two petitioners. This is Manu Bhai. Manu Bhai and Nattu Bhai. Shankar Bhai Patel is petitioner. It's petitioner number 2. And Manu Bhai. So what does this? This is so see, the record which have been produced show notice to Nattu Bhai.
Natwar Lal Gangadas Patel.
Whatever, Nattu Bhai petitioner number 2.
And
Where is the notice sent to Manu Bhai, Shankar Bhai Patel?
Right, may I? This
is separate record.
Yes.
All.
Right,
So
again.
The notice. What does this Panchanama say? Panchanama. What does this stationary level? One, two, three. Particular branches names of the copy. Which will be written.
Now, do you have the proceedings for the petitioners 1 and 2? Here it is Natwar Lal Mangal Das Patel. You have proceedings for petitioners 1 and 2.
Petition,
Yes. So this is not the record. This is not the record.
That is, that report pertains file number 241, 240. I just pass on this.
So what we are asking is that notice was issued to these two petitioners. You show that.
Notice was issued, one more aspect, again for repeating this. There is no challenge to the notification. Notices were issued, they were challenged before the court. Court did not grant them relief. Subsequent to remand, what their contention was.
Mr. You have read section 3.2. The only controversy is whether possession has been taken because the repeal act came into force. No.
Much later.
If the possession has been taken, then the question does not.
Possession has been taken by 41199.
That is what. So therefore, you are required to tell us that under 10.5 notice was given to these two people and they had received it, and thereafter you have prepared Panchanama. Simple.
But one more later.
These, who are these people? Manu Bhai and Nattu Bhai. These are two petitioners. Show us where the notice is issued to them. And the Panchanama, that's it.
Lord, as a matter of fact, my lord, they did not even file a counter affidavit before the single judge. Page 18 notes that, and therefore the single judge was calling for the records. Number of directions were given. They did not produce because they could not have established that the notice was dispatched. It was then received by the noticee. These are the two things, my lords. They did nothing, absolutely. And the Panchanama has been disbelieved, my lords.
Let's see.
Recorded. Whether it's in Telugu also, I am also fighting.
No problem. Brother, that's why we have handed over the record to him. He is going to do. No problem.
I can also read, but with not that influence.
Fluent. Oh.
Not that fluent.
All right. He will see. So these notices.
Yes.
This is something he's saying now. These things. Why is there? No, this one. This location. Something. So, Mr. C, the notice 10.5. What is the address? Like his name is written. That's it. What is the proof that it was dispatched and received by them? No, but since you are producing the record and we are having a look at it, you must point out what mode it was dispatched and whether, where is the acknowledgement? 10-5, 10-5. 10-5 is 31/8/1999. Manu by this thing you have issued. So it only mentions his name, no address, what and how, whether, how it was dispatched and where is the acknowledgement. That's it. Original you want, give it, madam. Give it to him. We will find out. Give it to him. Find out there is one envelope and this thing. Find out what is. You, Mr. Go through it. We will take it up at 2:30. Like after that case, after hearing additional advocate general for 10 minutes, we will take up, continue with this. You just see. The only thing is, Mr. C, under section 3(2) now of the Repeal Act, their contention is that the possession has not been taken and therefore the land should be restored to them. Learned single judges found. I mean, has decided in their favor. If you want to, you have to tell us that under section 10(5), the notice was given, I mean, dispatched by this mode, registered post, etc. Where is the acknowledgement? Are you relying on the presumption that, and therefore you have to tell that this was his address where it was posted, and if there is an acknowledgement, number one, whether when it was served. So, and thereafter the Panchanama, that is it. What else? See, wasting, nobody is questioning. Wasting of land under 10(3) has attained finality, nobody is questioning that. But your case is that much prior to Repeal Act, you have taken possession on 4/11/1999. Establish this by the record that you have taken possession, that's it. Memo of appeal. That was the rate petition. Not under 10(5). We'll see you, this thing, organize the record, you put flags properly, be sure what you want to say. Like what you're trying to now submission, you didn't make this submission that traveled, learned single judges traveled beyond the scope of the petition.
That's the reason I was pointing on the demand order.
But you should say so. We have noted down your three contentions. You have not said so. That he has traveled beyond the scope of the petition. That was not the grievance made by the petitioner.
I stand correct.
Not the stand taken. We don't know. Please see.
Yes. Good place.
All right. We'll continue.
The Lordships may only grant one indulgence, my lords. Rather, the record is seeing the light today. My learned friend may be allowed, my lord, to see the
yes.
report. In the presence of the officers.
Yes, he can, along with Mr. Prasad, he can.
Let him also give my lord, what is what.
Yes. Mr. Prasad, show him the report. While you.
I take the report back.
Yes. Give it back.
Lordships will assemble at 2:30 minutes.
See, we have one part.
I saw that.
Thereafter, immediately. Application,
Yes.
entry shall be
Does not
subject to.
confer any title over the property. my lord.
Correct.
That is true, my lord.
He
Insofar as
himself is saying that it doesn't confer any title.
that is true, that is the proposition of law that cannot be rebutted by me, my lord.
And you will make it subject to decision of this CS 14 of 58.
14 of 58, my lord. Certain findings are there which are still objectionable in the learned single judge order, my lord. One is that learned single judge had given a categorical finding that there is no dispute. That is not correct. No disputes in respect of this property. That is not correct, my lord.
Not correct. Very serious disputes. That's why all senior councils are appearing.
Insofar as the senior councils are concerned, well, the inter say dispute that can be established by them. I don't mind anything, my lord. I don't have any concern. Second point is, my lord, learned single judge in paragraph 14 of the improved order categorically given a finding saying that there is no title, there is no dispute in respect of title. My lord, that is wrong. My lord, Supreme Court, while my lord, your lordship may kindly just, I request your lordships to, I will look at page number 1.
No, there is a dispute. They also agree that there is a dispute. It can't be like this.
Next third point is, my lord, they are claiming on the basis of a compromise degree. My lord, final degree has not yet come so far in respect of CS 14 up to 1958. Fourth point is, my lord, there is no identification of the properties.
No identification.
Pursuant to the preliminary degree passed by this honorable court. These are 4 points, my lord. I wanted to bring to your lordship's notice, my lord. Just for the, my lord, your lordship, I kindly see the judgment of the interim order of the Honorable Supreme Court. These issues had been extensively dealt with the Honorable Supreme Court at page number 164. That I would like to bring to your lordship's notice and close. Your lordship, in fact, gave me 10 minutes. I am concluding within 3 minutes, my lord.
That's like you.
I am concluding within 3 minutes, my lord.
Friday, you were arguing something which was totally like, we didn't get it.
Yes, I am concluding within 3 minutes, my lord. Page number 164, my lord, your lordship may kindly.
164.
Bottom paragraph, my lord, 164. There are some parties.
Parties.
There are some parties seeking to raise claims over pieces and parcels of the property on the basis of being vendees. The larger issue is as to whether the vendors at all had a title, depending on whether the title vests with the government or not. Thus, the fate of these vendees would depend in turn on their status of the title in the vendor. My lord, next query is still relevant, my lord, Germain. We see no reason to expand the number of parties like these, my lord. Vendors have come adding. And these issues, as the question of ease of very title to the land in question and depending on the fate of the proceeding, the right of the other vendees would arise. These are my submissions, my lord.
What is this order of the Supreme Court?
Yes, this Honorable Supreme Court orders, my lord, 164. This matter is coming upon 30th October.
Against which order you have gone to?
Yes, against this order, my lord.
Page 60 is some other this thing. SLP.
Against the order passed in 19,303 of 2016. In a batch, my lord, I delineated a batch of in an index here. So
we want to know this. You are reading the order of Supreme Court at page 60, right? 160.
164, my lord.
So page 160 order, against which order you had approached Supreme Court?
The Telangana State Waqf Board.
WP number?
160, my lord. Against this order.
12548 of
page number 160, my lord. Writ petitions were. SLP numbers are shown.
No, this is Mr. WP number 12548.
Yes, my lord.
What is that order?
These are all in respect of the same village, my lord. Hafiz Fet village. All these lands.
No, but not with regard to this land. This is probably how much land? 24 acres.
24 acres.
24 acres.
27.
So this, Mr. AG, Mr. Additional Advocate General, this is not in correction with this survey number, whatever the land involved.
That is what I have submitted. There is no identification of the properties, no survey number. That is also dispute pending before the Honorable Supreme Court for the adjudication. As of now, there is no identification of the property subject to the final.
No, that's correct, right? But what is the order dated 30th March 21 passed in WP 12548? Is it on record?
May I tell you?
First index
that is declaring that a gazette notification of the Waqf Board is illegal. So this particular page 160 SLP is by the Telangana State Waqf Board. Well, let me see page 160, the cause title of the case.
Yes, Waqf Board.
And respondents are private parties who were the writ petitioners challenging the Gazette notification.
You are not party to this order.
No, we are not parties, we are not.
But the order under challenging before this honorable court had been referred to by a learned single judge in a judgment which is before the Supreme Court. Your Lordship may kindly see the same value millet, page number 5 millet. Your Lordship may kindly see.
Page
number 5 of this value millet, paragraph 7.
Yes.
Petitioner gave another representation on 27/4/2016 to the same effect, enclosing an order dated 17/3/2016. This is under challenge before your Lordship. Passed by this honorable court in writ papil number, this is the same writ petition, 15056 of 2014 for the adjacent survey number 77.
This is the writ petition preferred by some Kalyan.
Yes,
C.
Kalyan. Yes.
So petitioner is P. Kalyan.
Not Kalyan. In the Kalyan's matter, learned single judge had also referred to the order under challenge before this honorable court in the present appeal.
Yeah.
Millet, that is again, Millet, this is order 150, writ petition number 15056 of 2014. Millet, your Lordship may kindly come to paragraph 2 also, Millet. Paragraph, page number 7. On 22/2/2017, this court passed an interim direction as spread by relying on the interim order passed on 17/8/2016. This is order before your Lordship now. In writ appeal number 579, this is order appeal before your Lordship. Filed by the state challenging the order dated 17/3/2016 in writ petition number so and so, present writ petition, observing that the incorporation of the names of the petitioner in the revenue records and alienation by them of the subject land shall be subject to the result of the writ petition, and any document alienating the subject property, petitioner specified that such alienation is subject to the result of the writ petition. Well, now your Lordship may kindly come to the page number 160. Well, this SLP at page number, next SLP with the SLP number 2635 to 2636 of 2021. The Kalyan order is this, yes, writ petition. In all the matters, leave granted, status quo is granted. At page number 165. In all these matters, leave granted. In all these special leave petition, except number so and so, the existing order of status quo would continue to operate. Consequently, the contempt of proceeding may not proceed further. Further, your Lordship may kindly, in Supreme Court website also, this present writ petition is shown, is pending. All these connected matters are pending. It is shown by that in Supreme Court. In Supreme, 149, your Lordship may kindly. In Supreme Court website, yes, madam. 149, serial number 9, your Lordship may kindly see. They have referred to my Lord Justice M.S. Ramchandra and so and so. Repeat this, serial number 9, my Lord, your Lordship may kindly. 15056 of 2014. In Supreme Court website, it is shown.
All right. So, what is your submission? Then it's pending. Therefore, this no order can be passed.
Malat, I say what you are. Submit, Malat. Anyhow,
What is submission?
the prayer which they sought for, the respondent sought for before this honorable court had been considered by the government, and their names are being reflected in the Dharani. What more grievance I pose the question?
He says that it was reflected, then deleted subsequently. Huh?
In Patadar, it is reflected. The Lordship may say, in the Dharani, it is reflected.
Give the copies.
Yes.
So you have complied with, right?
Yes, because we are
Their appeal is that they will not show them.
No, but he says that
now
Patadar is shown.
See, what?
Number Patadar name. Vedre estate, it is written in Telugu. Vedre
estate 514.
Yes, Patadar name.
Survey number 77, correct?
77, yes, correct.
And what is the area?
That is next page, Millet. Where is next page, Millet? The total extent 24 acres.
24. Yes. What the your name is shown here. Please see.
And as your Lordship, as I submitted last time, subject to the result of this SLP and CS 14 of That much I can consider and I cannot subject. Ultimately, this issue has to be adjudicated by the Honorable
No,
Supreme
but this is, of which date and this you have taken a printout?
Today we have.
This is Dharani Integrated
Yes.
Record of Rights. They maintain a separate website for that. From that mallet, they have taken survey number 77. 77 by P. P in Telugu. That is part. P is part. Whether the Pattadar name.
Your name is there?
Yes, writ petitioner's name is there. So this is exactly mallet what I wanted in my writ petition.
No, it has been done.
No, but they were arguing the writ appeal mallet from the last. We have taken your lordship's time mallet. They have placed this before the honorable court earlier.
We have said, Mallet, at the outset of my argument, I was submitting that in obedience with the order passed by this honorable court, we have done this, mutating their name. At the beginning arguments of mine were this only, Mallet.
Now the only submission is this mallet, that this will be continued by them.
Yes, yes.
Discontinued.
Subject to the result of the yes.
This would be reserved for judgment.
My lord,
Yes.
may I make one submission, my lord, sir? Just acceptance, my lord, sir.
Ah,
In respect.
Yes.
Since we are not heard, my lords, in the pleading application before the writ petition, I'm sorry, my lords, subject back. Lordship may, my lords, refer back, my lords, so that we can argue the matter on merits, my lords, on the extent.
That we will consider, of course.
Yes, my lord, because otherwise we are not being heard at all, my lords. Writ petition, my MP is numbered.
Heard, right? Here
No,
you
that's
have
correct.
heard.
Why can't?
I see, Mr. This, I mean, society cannot take, no, see, there are one, like we are giving an illustration to you. Supposing there are 100 members of the society. All 100 members cannot engage a separate independent council and say each council cannot say that I will have a right to address. We have dealt with this issue.
It is not, it is on behalf of society, my lords. I'm sorry, it is on behalf of society. We are.
Society, so you have been, how you are saying that you have not been heard? He has
No,
addressed.
my lords, my WP MP is numbered, but lordship may look into the order, my lords, nowhere it is referred. It is not being heard at all.
That he has told us that he had filed an application for
Lordship,
intervention, that single judge has not adverted to it, we will deal with it.
I'm obliged, I'm obliged.
Yes. CAV? No. Me. Send it there on my table. Lunch motion. Yes. Yes, Mr. Ramesh.
16, my lordship.
16, all right. Page 16, 35 copy today. Next.
Please, lordships. The petitioner before lordship, she was allotted a seat in BDS. She was directed to report by 7/10/2023. Lordship, she could not report, lordships, owing to her financial difficulties, and she's been suffering with a fever. The time has left, lordship. We are seeking for extension of time so that we can appear before the concerned college and deposit the fees, lordships. She was allotted seat, lordship, page 27.
You will have to serve them, right?
Lordship, we have served them copy.
No, but that college, mister, respond number 3, he doesn't appear. See, you have been allotted a seat in respond number 3 college. Right?
Respond number 3 college, lordship.
Then you serve, we'll take it up tomorrow, day after.
Lordship, college have a standing council, can have tomorrow, we'll serve it today itself, lordship, if your lordship so pleases. What is happening, lordship? They're calling the stay vacancy seats, lordship, they're giving 10 o'clock, they're giving the web options and they're closing by 4 o'clock.
You are, this thing admitted which course?
BDS, lordships.
BDS. All right. And you had to report till 7th of October.
7th of October, lordships. We appeared before the college.
So tomorrow we'll take up, you serve a copy.
We'll
Mark the presence learned counsel for the petitioner submits that the petitioner was allotted a seat in BDS course and was
Wait, please, Your
Hmm.
The second respondent had conducted third phase knock-up counseling in the state on 4th and 5th October, my lord. My lord, for a minute, your lordship may kindly see.
No, so
Page
what
number
happened?
37. For a minute, your lordship may kindly see page 37.
What happened?
My lord, the neighboring state of Andhra Pradesh, what they did is, from second round of counseling itself, they said people who already got seats in All India quota round 1 and 2, and also from the state of Telangana in round and 2, they are ineligible to participate in Andhra Pradesh. My lord, the second respondent ought to have done that same thing. Now the result is, my lord, on 11th they published a list, 164 seats, my lord, which includes 70 clinical, my lord. They are the most sought after the seats, my lord, in government medical colleges and private medical colleges. They are left vacant. Now, my lords, yesterday on 14th midnight, my lord, they have issued a stay vacancy counts notification to fill in web options. My lord, and they now they have made petitioners or the persons who got seats in the previous rounds of counseling ineligible. In effect, now what is happening, my lords, is a candidate who has failed to secure seat in the first 3 rounds of counseling is now going to get a clinical seat in government medical college. This is completely against the spirit of merit-based counseling, my lord. Ultimately, the aim with which the second respondent conducts counseling is so that merit
No,
is given.
consequential allotment orders, who are the, in whose favor these orders have been passed? They are not parties to the petition.
No, my lord, there will be several and allotments are not
No,
given.
see the prayer.
Yes, my lord.
Page 7.
Allotments, if any, my lord. Because today, 2 o'clock, the options
No,
will
no, see, mister.
Lordship, lordship. I am aware, my lord. I am aware.
See the prayer. What does it say?
Lordship.
Let them seek his, you find out, Mr. Ask Mr. Rao to seek his, we'll take up tomorrow.
Only request, my lord, is today by 4 o'clock, they will give allotments.
It is all this at the 11th hour you come. What can we have to give them some breathing time?
Insufficient. It is not as if I have delayed, my lord. 14th midnight, they issued the straight counseling.
Fine. So what can we do? We can't allow the petition giving you admission right away.
Tomorrow morning, lodgement can stay.
No question. Nothing. You are before this court. We will see what I mean. Whose admission to be stayed? Nothing. You have not said anything, Mr.
Because they have not given allotment yet, my lord. Only web exercise.
Then you are. We don't know, Mr. Let him seek instructions. You ask Mr. Rao to appear. Accepts notice on behalf of so and so and prays for short accommodation to enable him to seek instructions.
Page number 16, madam. Page number 16, madam.
16. All right. Certified copy today. Yes. Mr. Yes, so.
I had brought to my lord's notice, my lord, the present writ petition which was allowed by the learned single judge. The grievance was no notice was served to the petitioners regard to the hearing.
That's this thing. That other previous case which was been sent to my district.
The grievance which was before the single judge was no notice was served regard to hearing dates. That is how they were before the court.
Hearing dates by the appellate
authority subsequent to remand.
Now, where is the writ petition?
The writ petition, my lord, starts at page 40 of the paper book.
40.
Yes, sir. The grounds which are at page 53.
One.
That's page 46 also, page 46 if you note, page 46. It refers to the earlier order, top two lines refers to the earlier order appeals, then third line. Writ petition number 18851 of 2003, filed by the petition, response by the petitioner challenging the common order passed by the first respondent, dismissing the appeal number 58 and 76 marked as so and so. Counterfeited filed by the special officer corporate authority.
Where are you reading?
Page 46.
Para 4.
Third line from the top, third line from the top. Writ petition number 18851 of 2003.
Yes.
Filed by the petitioner challenging the common order passed by first respondent, dismissing the appeal. This was the earlier writ petition which I brought to my lord's notice, where they had challenged it. But subsequent to thereto.
See, I mean, you need not labor on that point that the vesting has attained finally. See, Mr. The only supervening circumstance after vesting is the repeal of the act.
Yes.
So therefore, what
is the difference between that day and today's words? Kindly see 53 words. The grievance in the writ petition before the single judge was only notices
we are telling you that it has we have understood that 10.3 not challenged anywhere, not set aside. Fine.
Page 53 if you notice. Page 53. Grounds of challenge in the writ petition before the single judge. Page 53.
Status quo.
The order was passed. Grounds without giving an intimation to the appellant's petitioners. 5.3 minutes, 5.3. Next date of hearing after 23/2006. Subsequent dates date.
What? 1 minute.
Is the prayer.
Page
58 is the
53.
53 are the grounds. 57 the prayer starts. 57. The grounds, the first ground is they are not given hearing dates of hearing. They are not intimated about date of hearing. Then you also go to 57 minutes.
Oh, yes.
Page 5-7, main prayer. 5-7.
No, but after filing of the petition, the act was repealed.
After the petition, yes.
So then at least, I mean, have they said that they are in possession anywhere in the petition?
Most very relevant ground was date of hearing was not intimated. Principles of natural justice are intimated. All proceedings have to go.
Yes.
Kindly see page 57. Prayer I'm reading.
No, this petition, Mr. Please see by virtue of section 4 of Repeal Act.
Yes.
The proceedings of it. So therefore, I mean, there was no question of remanding the matter to the appellate authority because the act itself was repealed, right? So therefore, no purpose would have been served because the proceeding before the appellate authority By that time, supposing it would have been remanded, stood abated, no?
But for my lord's consideration, my lord, what I would submit is straight away going to my counter, I pointed out the dates of hearing which are sent by RPAD to the petitioner.
No, we are asking you whether writ petition contains an averment of fact anywhere that they are in possession and possession has not been taken.
The possession, I relied on 4/11/99. That was subject matter of the earlier writ petition. Dates were also there. 10/1, 10/3,
What
10/5.
is so non-service of notice of the appeal? So
Yes.
then, what is so then what?
I brought to the notice of the court by through a counter that notices have been served and also that respondents number 4 to 20 have been implemented in the appeal, who were the actual purchasers through agreement holders and purchasers through the petitioners, and also for the reason that the land is declared as surplus earlier, they have approached the authority seeking benefit under regulation of 455. The state ballot went on that by virtue of the request made, there was a GO issued converting the land from recreation to residential zone by the state, and also that benefit was granted to the petitioner. That was not finalized in the status quo orders operating in the present writ petition. That was the case. Present writ petition, there is an order by the learned judge. Therefore, nothing could be proceeded with further, though the lands have been related in favor of the third parties. Third parties, to bring it to my lord's notice, one aspect is for the application of GOMS 455, which I will show it to my lords, third party should be in possession by virtue of a document. But there was a finding.
When it was sold?
Different dates for different societies. But then, my lord, I need to go refer to another order of the learned single judge, my lord, where details have been set out. One other aspect is all the respondents who have purchased the property from the writ petitioners are also before my lords. They are in independent writ petitions, they are before my lords. Bringing to my lords notice how they have purchased the property. For me to my lord today stand before my lords to inform the court the proceedings which have attained finality by virtue of they being heard and appeal being dismissed, subsequently having carried forward in the writ petition, the learned judge has gone beyond the scope of the writ petition, has in fact gone into the area, my lord, which was earlier urged by the writ petitioner. Subsequently, they did not urge, they did not choose to challenge. Panchanama and all of those things were subject matter of the earlier writ petition before the learned single judge.
Where is that?
185, which I have brought to my lord's notice.
Where is that? Where the Panchanama and this thing?
10.5.10.6 was there. 10.5.10.6 was there before the court.
No, see, Mr. They must have did they raise a contention that possession has not been taken? When was the previous writ petition filed?
154 page, 8th August 2005 is the earlier writ petition order.
15?
8th August of 2005. But what I am trying to submit before my lords is, on this date, my lord, possession was already taken by the state. Kindly see, my lord, the order now. This I was bringing to my lord's notice. The challenge was specifically to notices under section 10.1, 18.594, 10.3.6694, 10.5.615.798. But these are all the dates, my lord, which are not in dispute, cannot be disputed now. In the record also, these dates are there. But this order, if your lordship sees the learned single judge's order, well, setting aside the order of the authority, the learned single judge remanded back to the authority for considering the case of the petitioner before this learned single judge. By recording the fact that the status quo order which was in operation was not brought to the notice of the court by the respondents. In fact, the writ petitioners contended that there is no status quo order at all, which is at page 158. 158, if your lordship kindly.
So what happened to the earlier writ petition? It was remanded.
Yes. Kindly see.
Why it was remanded?
Kindly see. It is explicit from the order passed by the authority was, I need not decide the appeal on weight because status quo is operating. By the status quo granted by the honorable court is operating. Therefore, the appeal was rejected. Then the authority just records the finding in 158 is explicit from the above referred order, and that view of the status quo order said to be granted writ petition appeals were dismissed. Neither the writ petition number nor the date of the order passed by the High Court is mentioned in the imbued order. The specific assertion of the petitioner that no such order has been passed by the High Court to their knowledge. This is the assertion made by the writ petitioners. So even the ground of assignment appearing on behalf of the respondent not in a position to say the writ petition number in which status quo order has been granted. If such is the situation, the matter needs to be remanded back to the authority. That's how the matter was remanded back to decide the appeal. No fresh appeal was filed. That was after hearing, it was dismissed. As against that, the writ petition was filed. The other judge has gone.
Yes, we have understood. Yes. Then
this is our case, but one of the recent Supreme Court judgments,
no, but this thing you didn't tell us from the record, right? We asked you.
Record. Well, one of the matter notice has been served. In one matter, notice is unclaimed record as per record. As per record, in one of the declarants matter, notices have been served, acknowledged. The other one matter, notice has been unclaimed. That is the record.
Which case? Where to whom it was served? There are two petitioners. You show when the notice was sent, when it was served.
In respect of petitioner number, I'll go by the petitioner number.
There are two, 1 and 2.
Yes. Manubai, writ petition number 1, Manubai Shankarbai Patel, 11, that subject matter of B/11 to 4076.
It notice was sent to him when 10/5 notice.
15th August 98. 15th 7.
July. 15 July 98.
Yes.
Huh?
Yes.
And when it was served on him?
1 second. But this is unclaimed.
Unclaimed.
Yes. So far as the second writ petition is concerned, Nattubai Shankarbai Patel Road, notice was served.
Sent on.
10/5 on 26/10/98. 26/10/98. 10/5.
10/5.
Yes. It was received on 5/11/98.
10/5/98.
26/10/98.
26/10.
Notice under subsection 5 of section 10.
Yes.
It was received by the declarant on 5/11/98.
5/11.
Yes.
And
Acknowledgement is also here. Acknowledgement also.
And you have taken possession?
Yes.
On
4/11/98 is our case.
So what is the, they hold different parcels of land?
Different parts.
What, like the first one, how much land?
But in the
note you have mentioned?
Yes. At serial number 4, Marat. Manubai Shankarbai Patel, extent is 18,375.29 square meters.
Yes.
This Marat, the earlier contention of my colleague was possession was not taken. This earlier contention is admitted by the state because notices were not served, unclaimed. To Nattubai Shankarbai Patel Marat, extent is 20,368. This possession was taken is our case, which I have set some dates also. Pachanama is 4/11/99. But what I would like to contend now before
you, this thing you give that, put a flag and give it to us.
This Marat, this flag Marat, record is
yes.
But whereas the declarations, this is the actual position of declarations filed, considered by the authorities. The other aspects of the matter, Marat, the lands being alienated, which is taken care of, taken by note of the authorities and regularized in their favor. Possession may not, unless the possession is there, may not, the regulation proceedings may not go on to the state. But these are all disputed questions of fact. What is in the possession now, as being claimed by the writ petitioner, is respect of the property which was actually alienated by the petitioner himself, violating the orders and also.
When alienated, you are just saying that you must give us dates. When order of status quo passed, when he alienated, when he filed the petition.
But this is extensively dealt with the appellate order words. I just have to read this words.
No, you tell us. Please tell us, we will note down.
Right, page 65 of the paper book, the appellate order. For Netaji Nagar Cooperative Housing Society. Page 65, running page. Netaji Cooperative Housing Society filed written argument saying that they have purchased the land in survey number so and so, acknowledging 16 acres, 0.5 gunta, 1 acre 35, 236 by 2 Udimalka through an agreement of sale dated so and so. The parents and his father family were paying entire sale consideration. That due to the pendency of ULC declaration, sale date could not be executed. Society filed OS number so and so. Generated into a
This is of survey number 236.
This is 236, 222 by 5 and 1.35 acres in 236. 224, 222 by 5, 16 acres, 5 guntas.
No, this is agreement for sale.
Subsequently, they approached the civil court, filed a suit.
My learned friend, what he is saying, that is not the subject matter of the writ petition.
224.
No.
222 by 5 is Manubhai Shankar Patel. 222 by 5 in the note which I have used.
The writ appeal 979 filed by the Netaji Nagar Society. We got implicated ourselves in the pending appeal because a part of the land is claimed by them.
You have purchased, right?
But I am the purchaser of very same parties.
When?
In 1981. We filed an
No, this is an agreement for sale, Mr.
Agreement of sale, right?
So agreement for sale, I mean, when the sale deed was executed.
But that's a recital. It's a society. Already filed a suit. They compromised the matter. They compromised the matter through court process.
Ultimately,
application before the government seeking a
writ petition to the courts of hearing, they have said that they are not contesting against, they are not claiming any part of this land, and that's the reason why we filed a memo, joint memo also.
The sale deeds which are executed by the other parties, not the reported.
Yes. So, part of the record of reading.
Like, get an opportunity, let him.
Misleading to the court.
No, not.
You will have. But I would not venture, but I have not done in my 30 years career.
No, yes.
So sorry.
No, we know.
What is there about?
No, let him say what can be done. Don't say like this, but you can have the opportunity to clarify it.
Yes. Misleading is some statement which I have not heard.
Yes.
I'll just read, but leave it there.
So, but this thing, when they have this agreement for sale, then when was the civil suit filed? What happened?
When in compromise and in pursuance of the compromise, petition has been delivered to the society.
There is civil, this all facts must be there on record, right? You are just saying.
Dates are
not there.
Then subsequent paragraph.
So what is the submission that since prior to filing of the petition, they had sold the land, therefore no locus to maintain the petition.
Sold the property and also the property which is regularized by the state at the instance of the same persons who purchased the property.
So was submission is prior to filing of writ petition, it was sold.
Yes.
So when it then you need to tell us when it was sold, when petition was filed. You are admitting that those dates are not there.
Yes.
Are they parties to the sale deed? Yes. Is it on record?
What I was mentioning to say, but all these societies are before my lot independently, but I thought they would make all these societies are also.
So we will ask them then.
Independently, they are before my lot, but not being agreed by the order.
Yes.
So one should hear the society and reply
Yes. Yes, you appear for whom?
Your election for the appellate in appeal 657 of 2011.
The rate appeal?
657 of 2011.
Ah.
Item number 35.
Ah.
I mean, just indicate that we have very serious objection regarding locus law. And we get that purpose.
Look. All right.
About the locus law, to have very claim over the land records that we know.
You know, I make my submissions. My friend appeared earlier also, my lord, before this honorable court. I know that.
Yes, yes.
He was here, my lord, when this is Satish Chandra Sharma, they were was with honorable Chief Justice here. We were on other sides also, my lord. Then also.
Oh, that's
My lord, I made my submissions, my lord. After I made my submissions, my lord, whatever the objections can be raised, they can.
Not arguing, I'm just indicating.
Well, indications can come later on. I was heard.
Yes, yes, you.
This honorable court matters were reserved for judgment and then they were opened, my lord. They were heard by justice.
That we can assure you that doesn't happen with this bench, right? So you need not, I can't help it with history, whatever happened, who heard it. If you have a grievance, go there, what redress, what this is, this happened.
Make myself clear, my lord, I said. It was heard by justice.
You will be heard. No.
She was elevated to the Supreme Court.
You will be heard, mister, and the case will be decided. You rest assured, within the time limit fixed by Supreme Court of 30 days, we will decide it. So don't worry about it. Please go ahead.
Now, since my friend said that I have no locus standi, I made my submissions earlier before this honorable court.
We are hearing you. We are hearing you. Please go ahead.
You have to answer to the objection raised by the learned senior counsel, isn't it?
Yes, also. So we are hearing you. He can't hear you and say that you don't have locus. Mister, you are an appellant in writ appeal 657. How can you be not heard?
Since he raised an objection, I have to clarify.
He said that he has serious objections to your locus. That doesn't.
I have to meet it, isn't it? I'll have to meet it.
So who is preventing you from meeting?
I'm making my submission.
No, that doesn't help that somebody heard it and released it. That doesn't.
On the question of locus standi, I was making myself clear, that I was heard by this honorable court, matter was reserved for judgment and then opened. This is also an aspect.
Which bench? Which bench heard? Which bench? When heard? Bench headed by whom?
This is Goyan.
And who heard? Who along with him?
Then when he was got
just we are noting down, right? All seriousness. We don't know how it is relevant for decision of this case, but still you are saying we are noting it down. Justice C.V. Bhaskar Reddy. Then when they heard, 1 minute, when they heard.
I don't remember the date.
Please see the order, give him order sheet.
It becomes relevant for the reason that objection is made that I don't have a locus standi.
We didn't say that we are not hearing you, right?
For an objection, I have to answer it.
Please. Yes, please answer. Give it order sheet to him. Tell us. No, please tell us. You are here to assist us. Please tell us. We are giving when it was heard, when it was released. So we will make note of this submission and record it that you submitted.
That submission is to the objection raised by the counsel on the other side.
We will
no locus standi.
We will record this also, that before you could address, he stood up and said, and then you responded like, we will record it in the order sheet. If you are so particular. Yes.
Okay. But the current counsel is also here, the counsels and the other side also there. Everybody was heard. Everybody was heard.
No, but also what shall we write that you didn't tell when it was heard? You please, as we were recording, please point out from record.
Yes. I think the learned, the court officer should be able to show to your lordship.
No, you are making a submission. We are given you the record. Please.
21.9.
21.9. Which 21/9, what year? 23, 24? Huh?
Well, you mentioned that the recorded that it was not by losses. SSP, Ujjwal Gulan and SSP.
But it has to be there, right? Please point out.
They should be able to point.
Which case? You are not finding it from the record. Or-
But that could arise in the event of any dispute, that it was not heard. The learned,
No, Mr. We want to clarify that we have never said that you will not be heard. I don't know why you are making this submission.
Since you are not asking the query.
What query? We didn't. You said that we have been heard and it has been released. So therefore, we are writing it in all seriousness. So which date you are required to?
Which part of the record?
Acha. So not part of the record.
Should be part of it.
Where is it? Then give.
I'm not aware.
Please see all order sheets.
Heard for 2 days.
We are giving you all order sheets. Please point.
I can't go through that. Sorry.
Why?
30.
Who will go?
3011. I don't have an access. 3011.
No, we are giving it to you. Why?
2020.
3011
3011 2022.
2022. Heard.
Yes.
And reserved. Then released. All right. Then next. No, this
Heard and reserved.
heard and reserved on 30th November 2022. Madam, find out 30th November 2022 order sheet. That
Friend is showing it from the net.
all right, it was reserved. Then yes, text.
My case.
We are nobody prevented you, Mister. All this we are hearing you with all our patience. You are not beginning. What to do?
Interbill 657. If you want to be please.
Yes.
It's
657. Madam, 657.
The petitioners are interested only in survey number 222/4.
Petitioner means appellant.
The appellants are not the appellate society is claiming land only insofar as 222/4 is concerned. Only survey number 222/4. Kindly take page 158 for once in order to make myself clear whether that insofar as the land of the petitioners are concerned, it is not a subject matter not before either the appellate authority or before this one. Page 158.
What is the order in your petition? Against which this WA has been filed?
Is filed with the same judgment.
Acha, this thing.
You have responded there not before the 11th April.
What is the order? Same order. Number 20. Acha, so this is. Yes.
Page 158 is lost. Please.
158. Yes.
The affidavit is filed, my lord, by Manubhai Patel on behalf of all the brothers who have filed their declarations, my lord, under the Urban Land Ceiling Act. Lords, can kindly go to page 160, my lord, in order to show to your lordships that the subject matter of the land of the petitioner, my lord, was never before the appellate authority or, my lord, before this honorable court, insofar as the declarations of 4 of the other persons are concerned have become final, and the land of the petitioner society falls in that land, falls in those declarations. Page 160, your lordship, please see. My lord, in the table below there, above, the survey numbers are given. My lord, 222/4, my lord, it's the second survey number. On the top.
Ah, 222. Yes.
My lord, sir.
Yes.
My lord, so far as J.S. Patel is concerned, my lord, in 222/4, he had 2 acres, 6 quintals. My lord, he has neither filed an appeal, his declarations have become final, and he is not there before your lordships also.
Arey, Mr. This thing, Prasad, you have in your synopsis, you have included, he is saying 222/4 is not covered.
The three, both the 3 and 4, if you're not, third. Part of the land.
1 minute, we are seeking a clarification because.
So part of the land was that. Kindly see.
No, but you, this you say 222/4 is Manu Bhai.
That
in your synopsis. He says it is somebody else.
No, column 3, if your lordships. Column 3 in the same synopsis. Nalini by Bipin Chandra Patel, Indumati Patel. 222/4 it is.
So his submission, you bear in mind, his submission is that his land is not under dispute in any proceeding, right?
His extent problem, larger extent.
My lord, if your lordship will come to, my lord, serial number 5, N.M. Patel. He has 3 acres, 12 guntas. 3 acres, 12 guntas and 60 yards. N.M. Patel is survey number 222/4.
Yes.
My lord, declarations have become final. He has not appealed against any of those orders. He is not there before your lordship. My lord, next is S.M. Patel. My lord, he had 3 acres, 12 guntas, 60 yards. My lord, S.M. Patel since expired, his children Anil Patel and Nandini Patel filed declarations and they are not there before your lordship. My lord, the land of the petitioner falls in the declarations of these 4 people. three people intact. In fact, my lord, it's only these three people. And they are not there before your lordship.
1, 5 and 6.
1, 5 and 6, I'm grateful. My lord, insofar as MS Patel, my lord, who is petitioner number 1 before your lordship, he has land, my lord, in survey number 222/4, but insofar as the land claimed by the, my lord, the appellant now before your lordships does not fall in the declarations given by MS Patel. He is petitioner number 1, MS Patel. The place of the appellant now before lordship in the society, my lord, their land does not fall in MS Patel's land. My lord, petitioner number 2 is serial number 4, my lord, NS Patel. He doesn't have land in survey number 222/4. Declaration doesn't contain 222/4. I have nothing to do, my lord, with this case, with these declarations. So this is a chart given by the declarants themselves, my lord, at the time of, my lord, declaring their lands, my lord, before the urban land ceiling authorities. My lord, against these declarations, my lord, proceedings were finalized on 24/2/1993 at page 106. Lord, these are the declared at page 106 is the proceedings finalization under section 8(4). My lord, these 8(4) finalization was made after, my lord, their objections, my lord, to the declarations given, my lord, at page 161, 81, page 161. 8(4) was passed after taking into consideration their objections at 161, page 161. 8(4) was finalized after the objection. Page 161, my lord, this is a draft statement. This is, my lord, by the petitioner number 1. Objections to the notice under section 8(1). My lord, last, if your lordship is pleased to see, even according to him, the share of the, my lord, make less than 1,000 square meters. At the last, my lord, 19,111.83 square meters of the area is held as excess in the ceiling limits by me in survey number 2/4, 236/2, and I am a member of the Hindu undivided family. My lord, what is finalized, my lord, in 8-4 proceedings, it starts at page 106. It starts, my lord, page 109, if your lordship will please to see. 109 in the middle. This refers to the petitioner number 1. Thus, the declarant holds the vacant land to an extent of 19,375 square meters, out of which an extent of 1,000 square meters is allowable to be retainable under section 4.1 of the Act, and is determined final as surplus vacant land order to an extent of 18,375 square meters in triple 2/4 and 236/2. Less than the objection. Lordships have seen in the objection, he said that his surplus declared excess land was 90,000, but the authorities followed under 8.4 declared it as only 18,375 square meters as excess. My lord, against which an appeal is filed before my lord, page number 113. My lord, during the pendency of the appeal, notice under section 10.1 was given, which your lord will get at page 118. My lord, in the appeal, there was an interim order which is at page 117.
Now, where is the notice 10.1?
Regular.
Notice under section 10.1, you just told
Page
the
118.
1.1.
117 is the interim order which was passed in the appeal. Page 118 is the 10.1 notice. My lord, 10.3, my lord, is at page 119. My lord, the gazette notification of my lord, section 10.3 is at page 120. My lord, the idea of a gazette notification is, your lordship knows, my lord, it is for the public at large, my lord, it is to the notice of everybody. And my lord, they have never disputed it. They received it. It was matter of subject to order of a challenge in the subsequent writ petition. My lord, after which, my lord, 10.5 was issued at page 123. My lord, proceedings under section 126, your lordship will get at page 124. 10(6).
Page
124.
yes.
My lord, next, my lord, is the taking over possession at page 125. This is what is set aside for Panchnama. The Panchnama is set aside against beyond the scope of the writ petition. The writ petition is filed by only 2 people. 125 will be taken over. Yes, sir. My lord, this possession was taken over, my lord, by the my lord, estate officer, page 126 last, if you want to speak, please, sir. Page 126 last. What was under challenge, my lord, was only by 2 brothers to the extent of their declarations. My lord, the declarations to the extent of other 4 people became final. And my lord, the possession was taken in respect of all people because 10(3) and 10(6) were complete. My lord, the learned single judge set aside, my lord, the taking over of the land of the Panchnama and 10(6), my lord, in respect of all the brothers. That is going beyond the prayer. Sorry, my lord, said estate officer, it's inquiry officer. Vicharana Adhikari, my lord, in Telugu, my lord, it is translated, my lord, becomes inquiry officer. The officer authorized to take over possession. My lord, the appeal which was brought to your lordship's notice in which an interim order was there, my lord, was dismissed by order dated 27/6/2002, which your lordship will get at page 128. That appeal was dismissed, against which, my lord, a writ petition was filed, my lord, by the petitioners now before your lordships in WP 18851 of 2003.
155.
18851 of 2003, which my lordship will get at page 140. 140.
Hmm.
My lord, your lordship may kindly see the prayer, my lord, in 140 for once. Writ of certiorari call for the records relating to the conducted directives relating to and connected with the order of the second respondent in appeal proceedings number 76 of 93 and 58 of 93. Only two of the appeals were there, my lord, against which only two of the appellants are filing before your lordship. Two of the declarants dated 27/6/2002, including the orders of the third respondent in proceedings number so and so dated 24/2/1993 and notices under section 10(1), 10(3), 10(5) of the Urban Land Ceiling Act in respect of properties held by the petitioner, and also proceedings number so and so dated 17/2/1993 and notices under section 10(1) dated 10/7/98, 10(3), 10(5) of the Urban Land Ceiling Act in respect of the properties held by the petitioner and all such signers. By which time possession of the land was taken. I bring to your lordship's notice another proceedings, which would show, that the petitioners acquiesced themselves to the taking over of the possession. And, my lord, after they filed the present writ petition before your lordship, which is now under appeal before my lords, it was a fortuitous circumstance, my lord, that the repeal came then, and now they are trying to challenge the taking over of the possession. Taking over of the possession was never under challenge. My lord, please see, my lord, your lordships have seen which were the learned government freedom sent to your lordships at page 145. Matter was remanded, my lord, to the appellate authority again by the learned single judge. My lord, kindly see just one paragraph at page 145 to bring to your lordship's notice that none of these proceedings under 10(1), 10(3), and 10(5) were set aside. They were though under challenge. Lord, kindly see 145 for once, my lord, just one paragraph. 145, the paragraph there. Accordingly, the writ petition is allowed, setting aside the orders dated 27 June 2022 in 58 of 93 and 76 of 93 appeal numbers on the file of the Commissioner Appeals Office of the Commissioner Hyderabad, and the matter is remitted back to the appellate authority, that is second respondent, for disposal afresh after hearing both the parties. However, it is further made clear that the status quo existing as on today is, my lord, on the date when the writ petition was disposed of, my lord, on 18/8/2005. Status quo existing on today shall be continued till the disposal of the matter by the appellate authority, by which time possession is taken is our case before your lordships. My lord, only to bring to your lordship's notice that pursuant to a 10(5), 10(6) and, my lord, taking over of possession, the government allotted this land to the APS artists.
When?
My lord, that is subject matter of the writ petition, which, my lord, the society now before your lordship challenged, which your lordships will get at page 138. 132, my lord, I beg your pardon. 132. Having taken over possession of the land, they allotted to the, my lord, to the APS RPC. My lord, the writ petition is filed, my lord, by the appellant now before your lordships. The society challenged it. My lord, the declarants, none of them challenged it, because that portion of the land, my lord, which was given to the APS RPC, my lord, falls in the four brothers. Therefore, my lord, these petitioners must not have challenged. The land, my lord, which was given to the society, my lord, I showed to your lordships, my lord, the subsequent proceedings of the government where the land is allotted to the government. My lord, these allotment, my lord, at page 132, the lord, please see the prayer there, filed by Tirumala Venkateshwara Housing Society, my lord, which is the appellant now before lordships, declaring the action of the respondents, page 132, my lord, in trying to take possession of the petitioner society land, being survey number 2/4 to an extent of 13 acres 10 kuntas situated at Timalkapur, Asif Nagar, Hyderabad district, Hyderabad, in the application dated 24/3/1982 filed by the petitioner society for exemption from the provisions of the ULC Act pursuant to GO 136 dated 28/1/1991 is pending disposal of the writ petition in so and so is arbitrary illegal. This writ petition, my lord, 137, my lord, if you not with this, these writ petition. 137 last. My lord, may kindly take 136, my lord, because 137 I'll be reading it in part. 136 last paragraph. But however, it is not the end of the matter. Admittedly, the petitioner has made an application for exemption under 20, and initially the government rejected the application even though it was recommended by the special office. But on a writ petition having been filed by the writ petitioner was allowed, the government was again directed to consider the matter, and according to the government, the matter is still pending. It has now been held by the Supreme Court in Special Officer versus Competent Authority 2010 SC. The consideration of application for exemption would arise only after the matter is decided under Section 10(3) of the Act. It is open to the government to exempt the land even after it had vested in it and possession was also taken. In the instant case, admittedly, the matter has not been decided by the government, and it is necessary that the government should decide the exemption application one way or the other. Till such time, it is open to the government to allot the land to any third parties as the application filed by the petitioner as early as in 82 is pending. Under these circumstances, I am of the considered to that the allotment of land in favor of APSRTC is wholly unwarranted without jurisdiction. Accordingly, the orders of allotment made in favor of APSRTC is set aside. Last paragraph. And WP number so and so is allowed. Pausing here, I would only like to submit to your lordships that here, my lord, the entire proceedings was, my lord, the government took over possession of the land from the four brothers, which land, my lord, was in possession of the petitioner society. Therefore, they challenged it. The allotment made in favor of the APSRTC, the RTC and the government are party here. So that against which, my lord, an appeal is filed, my lord, by the APSRTC. Page 147. APSRTC filed an appeal against page 147. Route 151, not please. Earlier to that on facts. The order of the division bench starts at page 147, 151. Paragraph 151. The court, while admitting their interface, suspended the judgment of the learned single judge dated 23/7/2002, passed in WP number 837 dated 14/8. During the pendency of the interface, ULC Act has been repealed by Act number 15 of 1999, with effect from 18/3/1999. As contemplated under clause 252 of the Constitution, the state government issued notification through GOMS 603 revenue dated 22/4/2008, extending the repeal act in the state of Andhra Pradesh with effect from 27/3/2008. 27/3/2008. Admittedly, possession was already taken by the corporation or the state. As per the finding recorded by the learned single judge, once any vacant land is vested under section 3 of section 10, possession of which has been taken over by the government or any person duly authorized by the state government, repeal of principal act shall not affect with regard to abatement of the proceedings. Therefore, all the proceedings relating to any order made or purported to be made under the principal act pending immediately before the commencement of the repeal act, before any court, tribunal or authority shall abate to section 3 of the Urban Land Ceiling and Regulation Repeal Act. Section 4 shall not apply to the proceedings only in relation to 11, 12, 13 and 14 of the Principal Act as per proviso to section 4 of the Repeal Act. Having regard to the said fact, we have no hesitation to hold that the direction issued by the learned single judge consider the application filed under section 20 of the ULC stands abated and no orders need to be passed by the state government as per the direction issued by the court earlier. The writ appeal is accordingly allowed. Possession of the land was taken is the recording of the division bench. Therefore, they said it is open to the government to do whatever they like. And but that the application of the appellate society need not be taken into consideration if the finding given by the appellate authority. Against which, the against which the appellant now before Lordships was the petitioner, the appellant, petitioner, the writ petition there, filed a review before this honorable court. That review order, your Lordship will please to see in the additional material papers which are filed. 22 to 2022. Order and review.
22.
22 to review Lordship's pardon. The review order is dated 19 to 2013. 19 to 2013. These are filed and additional material papers from 22 to 2020.
657. Which page?
Page 2 now. A lot of got division bench judgment. This is NV Ramna and this.
You are referring to this IA 1 of 22?
No, bro, it was filed along with the memo.
Memo. See, this memo.
Yes.
Page 2, madam. Page 3 is the order, if you're actually page 3. It's a small order, my lord, you're not kindly permit me to read it. The present application is by praying to record the issuance of GO 640, Revenue Department, dated 28/5/2003. My lord, I'll just shortly bring to your lordship GO 640. Asked in writ appeal number 928 of 2003. Writ appeal 928 of 2003, which is said the order dated 23/7/2022. Passed in WP number so-and-so by a learned single judge, directing the government to consider the application made by the petitioner for exemption of the land under section 20 of the Urban Land Ceiling Act in terms of the guidelines contained in GO 136, dated 28/181, was allowed by a division bench of this court dated 1/12/2010, holding that the direction issued by the learned single judge to consider the application under section 20 of the Urban Land Ceiling Act stands abated in view of the said act being repealed, and as such no orders need be passed by the government. It is submitted to the Petitioner Society has already filed an application in terms of GO 455, dated 29/7/2002, seeking regularization of the land under Urban Land Ceiling and Regulation Act, and the benefit was extended to the Petitioner Society, regularizing 49th block in favor of its members, and consequently GO 640, dated 28/5/2003, was issued. And even though the said GO was issued prior to the disposal of the writ appeal, inadvertently, it was not brought to the notice of the division bench while disposing of the writ appeal, and therefore the division bench has left it open to the parties to avail the remedies as are available under law. the petitioner society now seeks to incorporate factum of issuance of GO 640 dated 28/5/2003 in the judgment passed in the writ appeal. Heard the learned government pleader revenue and learned standing counsel for state court conference. They did not raise any objection as to the incorporation of GO 640 dated 28/5/2003. In the judgment passed in the above writ appeal, in view of the fact that the petitioner society has already availed the benefit of regularization in GO 455 dated 29/7/2002 and GO 640 dated 28/5/2003 came to be issued in favor of the petitioner society. The same is recorded in the judgment passed in writ appeal number 928. It is needless to observe that there is no necessity for the petitioner society to approach the government once again. The miscellaneous application is accordingly ordered. No order as to first. And overly with GO 642 issued in favor of the petitioner society on 28/5/2003, much before the writ appeal was passed. Hyderabad, a subject matter not be based. Tirumala Venkateshwara Housing Society. Regularization brought to the members of the petitioner society by way of allotments under section 23(4) of the Act. Overleaf at page 6, my lord. Para 4, my lord. In the circumstances stated by society, the government consider it necessary to relax the orders issued in para 4 of GO read above to enable the society and its authority members to apply for allotment in terms of GO read above. However, they consider it appropriate to restrict the said relaxation only to 49 plots reported to be vacant and not covered by any encroachments as informed by the society. Therefore, there is relaxation in order so and so. Last, I note your lordship, please. But last paragraph, page 7, allotment shall be subject to there being no litigations pending against the allotment in respect of the surplus land, which shall be thoroughly verified and reported by the special officer to Office Authority. But in the writ petition, there was pending. But in the pendency of the writ petition, there was an order of status quo. Therefore, these orders will not have been passed.
In the statement giving the justification, so people to say, between 23, some people it's supposed to be deleted. In the individuals have to be deleted. Yes, please help me recite the given statement that we say it should be deleted. This is not perspective. Yes, we show which are.
And true to your lordship, the GOs which were issued may not insofar as the petitioners are concerned. IA1.
IA1. 1 of 22.
Yes.
Yes. Yes.
Has been filed. Proceedings which are being through.
Yes, yes, copy. This is GO. Yes. Yes.
Page 4 may not be the proceedings of the government, may not insofar as
Page 4.
Page 4, my lord, this is GO 136, which was referred to as grant of exemption to vacant lands held by excess landholders approved to be transferred to the registered cooperative housing society and food housing cooperative societies guidelines for processing exemption applications under 21. So these exemption, my lord, for grant of exemption was extended at page 30 by another GO 91. Page 14, my lord, is the land which was converted to what basis from agriculture to non-agriculture, from conversion to residential. Page 14. My lords, may kindly see the references. Reference at page 2, my lord, reference 2 is Timbala Venkateshwara Housing Society, my lord, which is the appellant before your lordships. This is GOMS number 263. The draft variation to the zonal development plan for zone 6 issued by government memo 4th read above was published at page number 18 of AP Gazette. No objections or suggestions have been received from the public within the period of 15 days since the draft variation is confirmed. In the last exercise of powers conferred under section 3. Variation is at page 2, my lord. Page 15. Sorry, overleaf. Variation, my lord, inside in survey numbers, my lord, 222/4 is there. Udimarkapur village, Thanu, Hyderabad district is earmarked for recreational zone and the boundaries of which are mentioned below and we are designated and is now designated for residential use only. Over page 16 is the type copy, my lord, pardon me, 16 and 17 is the type copy. Our tentative layout is there at page 19 of the various 49 plots, page 19. This tentative layout of the society falls within the maps which your lords will get at page 164. The individual declarants, it is the 6 brothers therein. They filed individual declarations along with the maps at page 164 to 170. Only for your lordship's consideration, 164 to 170. And these land of the society falls in those maps which are not subject matter of the appeal before your lordships. Number. Page 165 is that of the petitioner number 1. It's a petition number 1, is respondent number 1 in the appeal. The land of the society does not fall in the land belonging to the respondent number 1 before your lordships. My lord, insofar as these 49 plots are concerned, my lord, it falls in survey number 222/4, my lord, which were declared as excess of the 1 to 4 brothers which your lordships have seen, and they are not challenged either in appeal or come before your lordships. My lord, I'll only cite 2 judgments for your lordships' maintenance. In the paragraphs I have. So there would be one issue, my lord, which I would like to bring to your lordships. My lord, there was an agreement between the petitioners by the appellants and, my lord, the landlord at that time, at the time of declaration. My lord, the suit was allowed, appeal was, appeal, my lord, suit of the society, my lord, since they tried to, my lord, dispute the agreement of sale, they filed a suit for specific performance. Suit for specific performance was decreed, against which an appeal was filed. Appeal, my lord, appeal was allowed. The suit was dismissed. Appeal was allowed and the suit was dismissed, against which, my lord, the matter was carried to Supreme. In the Supreme Court, my lord, when the matter came about a month back, my lord, the SLPs were withdrawn for the reason, my lord, that the possession of the land was taken over by the government, and there is nothing that rests with the, my lord, the petitioners by the owners, by those 4 brothers. So there was nothing. And this is the order in the SLP also. Yes, one. Why is that? Good. Where is this?
This is appellant's appeal.
But since those 4 brothers' land, my lord, was taken over by the government, possession was taken, they never disputed that lands either in appeal or came before this honorable court. My lord, the land, my lord, which was taken over possession and given to the APSRTC, my lord, was set aside for the reason that 640 GO in favor of the petitioner society was already issued. My lord, the kindly see 2 judgments, my lord, they can't actually dispute these taking over of possession on a, because there is a fortuitous situation that the, my lord, the Act was repealed. 2015 5 Sir. 2015 5 SCC, page 321. Para 1, what's this? 1 para 1. It's 3 paragraph for your notation. These appeals by special leave are directed against the order dated 21/9/2010 passed by the division bench of the High Court at Guwahati, whereby writ appeal filed by the respondents herein has been allowed. Order dated 13/4/2007 passed by the learned single judge of that court is set aside as the respondents are held entitled to restoration of the possession of the land in dispute. My lords, may kindly go to para 13. 13. The case of the appellant is that actual physical possession of the land was taken over on 7/12/1991. No matter unilaterally and without notice to the erstwhile landowner. That assertion is totally denied by the respondents, giving rise to seriously disputed questions of fact may not be amenable to a satisfactory determination by the High Court in exercise of writ petition. But assuming that any such determination is possible even in proceedings under 226 of the Constitution, what needs examination is whether the failure of the government or the authorized officer or the competent authority to issue a notice to the landowners in terms of section 10(5) would be itself mean that such disposition is no disposition in the eye of law and hence insufficient to attract section 3 of the Repeal Act. Our answer to that question is in the negative. We may say so because in the ordinary course, actual physical possession can be taken from a person in occupation only after notice under section 10(5) is issued to him to surrender such possession to state government or the authorized officer or the competent authority. There is good enough sense in that procedure in as much as the need for using force to dispossess a person in possession should ordinarily arise only if the person concerned refuses to cooperate and surrender or deliver possession of the lands in question. This is the rationale behind 10(5), 10(6) of the Act. But that would be the position if, or for any reason, the competent authority of the government or the authorized officer resorts to forcible disposition of the erstwhile owner, even without exploring the possibility of a voluntary surrender or delivery of such possession on demand. Would such use of force vitiate the possession itself, or would it only amount to an irregularity that would give rise to a cause of action for the agreed owner or the person in possession to seek restoration only to be dispossessed again after issuing a notice to him? It is this aspect that has to an extent bothered us. The High Court has held that the alleged disposition was not preceded by any notice under 10(5) of the Act. Assuming that to be the case, what that it would mean that on 7/12/1991, when the erstwhile owner was dispossessed of the land in question, he would have made a grievance based on 10(5) and even sought restoration of possession to him. No matter he would, upon such restoration, once again be liable to be evicted under section 10(5) and 10(6) of the Act upon his failure to deliver or surrender such possession. In reality, therefore, unless there was something that was inherently wrong so as to affect the very process of taking over such as the identity of the land or the boundaries thereof or any other circumstance of a similar nature going to the root of the matter, hence requiring an adjudication, a person who had lost his land by reason of the same being declared surplus under 10(3) would not consider it worthwhile to agitate the violation of 10(5), for he can well understand that even when the court may hold his contention that the procedure ought to be followed as prescribed, it may still be not enough for him to retain the land for the authorities to the very next day dispossess him from the same by simply serving a notice under 10(5). It would be in that view of an academic exercise for any owner or person in possession to find fault with his disposition on the ground that no notice under 10(5) has been served on him. The issue can be viewed from another angle also. Assuming that a person in possession would make a grievance no matter without much gain in the ultimate analysis, the question is whether such grievance would be made long after the alleged violation of 10(5). If actual physical possession was taken over from the erstwhile owner on 7/12/91, as is alleged in the present case, any grievance based on 10(5) ought to have been made within a reasonable time of such disposition. If the owner did not do so, forcible taking over possession would acquire legitimacy by sheer lapse of time. In any such situation, the owner of the person or the person in possession must be deemed to have been waived his right under section 10(5) of the Act. Any other view would, in our opinion, give a license to the litigant to make a grievance not because he has suffered any real prejudice that needs to be redressed, but only because the fortuitous circumstance, may not here also, only because the fortuitous circumstance of a repeal act tempted him to raise the issue regarding disposition being in violation of the procedure prescribed. The result, melody, the went on to discuss and melody appeals were allowed. Land was restored to the government only. Page, one other, 2010-13 SEC, page 158. Page 53 could also be placed for once. 53. Para 53, my lord, page 183. Page 183, my lord, para 53. Once vesting takes place under section 10(3) of the Sealing Act, the state has absolute title and ownership over it. The owner has no further say in respect of the land that has vested in the state. This position has been explained in Sulochana Chandrakant Gulande. The judgment is extracted. That's how all the judgments were referred to. Overly at page 185, last subpara of this case of para 53. View of the above, the law can be summarized that once the land is acquired, rest in the state from all encumbrance. It is not the concern of the landowner how his land is used and whether the land is being used for the purpose for which it was acquired. Acquisition issue also was taken up. Page 85 and 86, that's all. Only two paragraphs. 85 and 86. Similar is the fortuitous circumstance, you cannot now agitate this possession at this stage. Para 85 and 86. Page 85 relates to Panchnama. As pointed out earlier, the expression civil appeals are allowed carry only one meaning, that is the judgment of the High Court is set aside and the writ appeals are dismissed. Moreover, the determination of surplus land based on the declaration of owners has become final long back. The notifications issued under Section 10 of the Act and the Panchnama taking possession are also final. On behalf of the state, it was asserted that the possession of surplus land was taken on 1993 and the Panchnama executed showing that the possession had been taken. It is signed by the witnesses. We have verified the details which are available in the paper book. It is settled law that where possession to be taken of a large extent of land, then it is permissible to take possession by a properly executed Panchnama. 86 is also same. Let's kindly see the prayer in the writ petition and what was allowed. That's all. Prayer in the writ petition and allowed. But it was allowed beyond the scope of the writ petition. What my friend says here is, if it is allowed to the extent of the petitioners, we are also not bothered. But what was taken over possession by the APS RTC is the land where these 49 plots are there. Land taken over by the government, handed over to the APS RTC was never questioned by the writ petitioners before your lordships. They have acquiesced themselves to the proceedings of the APS RTC and taking over. Specifically of us, they have acquiesced themselves to the entire activities. Pleasure.
Who else? Anybody for the appellant? Huh? 35. 734 of 11. We'll continue tomorrow that. Tomorrow. Mark this out. Huh?
I replied to this case that some other day. Not a very long exercise.
We can come up only after vacation now, but 3 days we can. All right.
There is some paper without case lodges.
All right, so then your colleagues would be there. No, we can fix it on 31st October in that case. After hearing him, you argue, or whosoever appellants for his reply, will fix it on 31st October. Correct.
Since I've already fixed my since now.
This 6th, forget about it, but everything what we have. 30th, what 31st? First also, 2nd also is all right with us. 2nd November.
Second. That is just the orthodox case. That's all the Six, my lord, full details are only.
6th. 6th is a Monday. All right, we'll see. Ask your colleagues to make a request tomorrow then, right? Because we will hear him. All right, yes. Learned additional advocate general, special. WA number.
Vishwanath Srivastava.
Yes. Yes. Yes, yes. Okay. Yes, yes, yes.
He was here for 6 years, man.
Oh, yes, yes, we know. Yes. So we can hear you tomorrow, and who else? That's, you are the only person, then you may. You are,
37, that's only.
so you argue tomorrow. Like, take your own time. It's not this thing, and yes, yes. Okay.
Madam, I think